चलिए हम ये मेरे सब सेकंड हाफ में
In case of additional party, my motion is appearing in the mandatory combined.
I repeat, please start your mentionings from Monday. Let me include the matters in the list. Since I was not here for 2 weeks, some matters have not been included. Let me complete the inclusion. Please mention on Monday.
My lord, may I permit to mention, my lord, urgent leave to, my lord, move this application, my lord.
What is the urgency?
My lord, 22nd is the, my lord, date for, my lord, demolition of the, my lord, by the National Highway Authority. My lord, earlier writ petition, there is a order that, my lord, statutory appeal has been filed against the order. My lord, during the pendency of the statutory appeal, my lord, they have issued notice that 22nd.
Come back.
Yes, my lord.
Leave is not necessary.
Lost.
18th.
My lord, then, my lord, I supply the number, my lord, Monday matter will be appeared.
The
My
number.
lord, may I be permitted to mention item number 125 of the combined monthly list? My lord, under compelling circumstances, I'm mentioning this, my lord. It's an order of resumption of land which I am in occupation. My lord, it has been passed, my lord. Now they are trying to dispossess me.
Monday.
Monday, my lord. Very well. I'm putting in the slip. My lord. I'll come back on Monday, my lord.
Monday, yes.
But I'm
Lordship, may I permit it to,
Monday, please.
very well.
Lordship, may I permit it to mention one matter?
My lord.
Sure.
Yes.
My lord, matter
I
is
have
solved.
just said something. Have you heard, sir?
No,
You have not heard what I have said just now. All the mentions will be taken up from Monday onwards.
Lordship, item number 41, Lordship, today's list, Lordship, under compelling circumstances, Lordship. Yes.
Today's list, please do not mention. Let it be called.
restoration application.
My lord, correction of
Monday.
correction of my lord's order.
Give the
Order, my lord, the only thing, my lord, my learned junior had appeared when the matter was called. Even the live streaming I can show right now.
appearing.
His name is not appearing and it has been recorded. None appears on behalf of the private respondent. I can show the live streaming here and now. It shows that he has appeared, my lord.
Did not mention that he was appearing in the matter.
Ma-
These
ma-
corrections cannot be done. I'm sorry. No. cannot.
My lord, I can show that he has in fact submitted, my lord, before my lord, and my lord had in fact told him that his contentions can be taken up for consideration before the appropriate authority, since a consideration order was getting passed, my lord. I can show, my lord, if
None appears, then I don't think any correction is necessary.
but my lord, he had appeared. My lord, I can show from the live streaming here and now, my lord, if deems fit.
Come back on Monday. Let us see.
If my lord,
Rectification for order.
Yes.
Rectification for
Monday, please.
correction for order.
Correction. Give the number.
made appear as to be mentioned on Monday.
No, no. Call the days list, please.
Calling from to the list item number 1. My lord, the matter has come at my instance, lordship.
What's the
My lord
correction?
passed an order on 27th of July. Kindly see the order. And as it appears from the order sheet, my lord, there are 4 typographical errors, lordship. I have marked it, lordship. Kindly see it. My lord, kindly see in the I
Have you
appear.
put the other side on notice?
My lord,
Have you put the other side on notice?
my lord, this was not noticed. My lord, the typographical mistake. Kindly see, lordship.
Put the other side on notice if you require a correction. Please
very-
serve and come back.
Very minor mistake, lordship.
Minor, major, whatever. You have to put the other side on notice when a matter is moved, isn't it?
Lordship,
Please put the other side on notice and come back.
lordship,
There are several respondents, I find.
yes. No, there are several respondents. Instead of private respondent, it should be state respondent.
Please put them
That's
on
the
notice.
mistake. Lordship. Well, may I come back on
And
Monday? Lordship. Lordship.
not today, Kurun.
Lordship.
Item number 2.
Lordship, I am for the petitioner, Your Lordship.
My lord, I beg to appear for the state respondent.
What is the application?
Your Lordship, this application is for restoration.
You have no objection to this?
My lord, I have not received the copy and I have not been engaged by the, I was engaged in the WPA, which has been dismissed for default, my lord.
I have served, but unfortunately, Your Lordship, I am
It has been served to the department, my lord.
learned friend that he has not received the
As
copy.
to
but
my
this-
information, it has been
But
served
this
to the
application is
department.
just for restoration, Your Lordship. If Your Lordship permits, Your Lordship, I will serve the entire copy
Within time?
within time, Your Lordship.
Please serve him a copy.
Lordship,
Give yourselves.
I will serve.
It has been served. to your department.
আমি আজকে দিয়ে দেবো কপি এটা ইনভেস্টিগেশন আমি মেন রিট পিটিশনও কপি দেবো এটাও কপি দুটোই দেবো আচ্ছা
Let the writ petition be restored.
রেস্টোরেশন জাস্ট ফর
অবজেকশন করছি না
Can
কপি চাই আমি।
2 of 2022. This is an app 2022. This is an application for restoration of the writ petition, which was dismissed for default by an order passed on 16th November
আমি এখন কি
2020.
করবো আমি যেটা বলো ওটাই করছি আমি দুটোই দিব
Paragraphs. Sufficient ground to be made out.
ঠিক আছে ঠিক আছে
The application is allowed.
ঠিক আছে
Paragraph, the order passed on 16th November 2022 is set aside. Paragraph, the petition is restored to its original file and number. Can such and such is disposed of. Shall we deal with the writ petition today?
লর্ডশিপ এনিথিং
Not today, my.
WPA the order code. And let the matter appear under the heading motion on 11th September.
লর্ডশিপ মাছ
Lord, I appear for the respondent.
Lordship, Jyotin Kumar is appearing for the petitioner, Lordship.
Yes.
He is suffering from viral fever, Lordship. I am praying accommodation, Lordship. Kindly fix any day after Wednesday next week, Lordship.
It's my lord, it's a hearing matter, ready matter.
Affidavits
And
are
it will also require time. It's a cancel.
exchanged.
Yes, affidavits are exchanged long before. My lord may direct this matter to appear under the.
Heading hearing.
Yes. It's a hearing matter.
Lordship, kindly fix it on Wednesday, Lordship. Let him come back because he is suffering from viral fever, Lordship.
Next Wednesday.
Hearing matter. Affidavit was-
My lord may fix any date as your lordships.
The application is chilo, huh?
Application.
There's an application pending.
Yes, Lordship, there is-
Application recently, an
application.
application, yes. Recently, an application has been filed. It has not been dealt with as yet.
Let it be heard along with the hearing,
Yes,
because this is
yes,
for
yes.
restoration of possession. The application is for restoration of possession.
Restoration, it will, it will strike at the root.
That's what I'm saying. Let it be taken up at, along with the hearing,
Yes.
the main application, the writ petition.
And lordship will kindly add one line, if necessary, we may file response to that application,
To the application.
to the application.
Then it will come under heading application.
No, my lord, what my lord is saying that this
Action is
application
there.
will be heard along with the main rate application.
Because the application pertains to the writ petition
Yes,
itself, isn't it? You've asked for restoration of possession. That will go to the root of the writ petition.
Yes,
Root
Lordship.
of
If you
the.
deal with it on merits.
Only I am taking that liberty. If necessary, I am.
Affidavits are complete. Paragraph, the matter is ready for hearing. Paragraph, learned counsel for the respondents seeks to use an affidavit in opposition to the application being Can 1 of 2023, comma, if required. Paragraph, on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the heading hearing, group 1 hearing.
Give me 2 weeks time to file opposition and then your lordship.
13th September.
Much on.
Along with Can যেরকম ভাবে আছে ওইভাবেই থাকবে।
ঠিক আছে হ্যাঁ থাকবে একসঙ্গে থাকবে
Item number 4.
হ্যাঁ এটাতে আমাকে স্পেশাল ঠিক আছে But in this matter, there was an application by writ petitioner on behalf of my client for amendment of writ application in view of some subsequent events coming on record by way of affidavit which was directed to be filed. Now, my lord, if your lordship may kindly look to the last order, 28th July. On that date, I was not present. My learned friend appearing for state has filed an opposition.
Yes.
We would like to pray for 2 weeks' time for filing reply,
Go to file a reply to this.
amendment application.
The can 2 of.
Your copy has been served upon them. Yes, yes, I have received.
2 of
They have
2023,
given
the
us.
order can. Learned counsel for the petitioner seeks to use an affidavit in reply to the affidavit in opposition,
In respect of
Submitted
can number
on
2 of
the
2026,
state respondents. Paragraph, let the matter appear under the same heading
after 2
on
weeks. Any day after 2 weeks.
1st September.
Grateful. Grateful. বলছি আপনি আর সে দুজনই আছেন নাকি শুধু আপনি আছেন?
আমি সমিতিতেও আছে, আমি ডিল করব। তুমি আমার কপি দিয়ে দিবে।
না, সেটা ঠিক আছে, আমার কনফিউশন। আপনি শুধু আছেন, তাই তো?
Item number 5.
Your lordship, I appear for the petitioner, your lordship. Your lordship, this is my contempt application and the order has been complied with, your lordship.
The state, I in compliance report, my order has been complied. Compliance report. After the
Affidavit of compliance submitted on behalf of the alleged contender is taken on record. Paragraph, it is submitted on behalf of the applicant petitioner and also appears from the affidavit of compliance that the order under contempt has been complied with. Paragraph, in view of the above, the contempt application being the CPA and such is disposed of. Paragraph, there shall however be no others to costs. Urgency required. Website.
Yes.
Deeply obliged, your lordship.
Item number 6.
My lord, in this matter, my lord, I am for the state respondent.
Contempt
My lord, in this matter, my lord, after inquiry, it was detected that only 0.165 acres, my lord, was utilized by the PWD. Or other lands, my lord, there are 4 plots, my lord. The other land was not utilized. So I issued notice before the PWD to say whether you take that land or not. If you ask, if you decided to utilize the land is purchased, then you must answer the same, my lord. My lord, this is the position. So, my lord, I pray 1 week time, 1 month time, my lord, as because calculation of the
Order is at page
utilized
45.
land, my lord, is already, my lord, if your lordship will see the, একটু দেন না দাদা, এটা তোমাকে দিচ্ছি না, internal report.
Direction was to complete the proceeding for direct purchase
My
and
lord,
prepare.
my lord, the funds have already been placed. My lord will.
Yes, for that purpose, my lord.
The order itself, it is stated, my lord, that funds are already
Fund
available.
is placed for that particular piece
My
of land.
Now-
It has been utilized.
My lord.
So, will you be happy with that part only?
No, my lord, for the entire strip, I am told, my lord, for the entire strip, it has been, fund has been allocated.
No, no.
The requiring body is saying that they are willing to keep the entire land, my lord.
My lord, up
But
till
the
now, my lord, they are not.
Land
giving it.
acquisition collector is, my lord, stating
Notice টা ধরে দাও।
that only the utilized land will be paid for, the payment will be made for utilized land. This is the notice, my lord, we have received, sir.
ও, তোমাদের notice দিয়েছে নাকি? Everybody was present. Report কোথায়? What is the report? Political inquiry.
My lord, the requiring body, my lord, the
A
petitioners and the,
communication has been made to the requiring body, asking them whether they are eager to keep the entire land.
my lord.
So wait for some more time because it is in process. It's not that they are not complying, isn't it?
At least some progress that I can admit, my lord, some progress has been made, my lord. But
রিপোর্টটা কোথায়?
but they need to furnish the report by the requiring body, my lord. Requiring body, I am told, my lord, in presence of the requiring body petitioner and the acquiring body, my lord, inspection was held. A report was prepared, my lord. From that report, it will be clear, my lord, this stand taken by the requiring body, my lord.
Let us wait for another month and see.
Fine.
Because it is progressing.
থাক, আমার একটাই কপি। একটা copy কি ছিল?
You can take this back in fact.
My lord.
এই দুটো ফেরত দিয়ে দেবেন দুজন। একটা petitioner একটা
আমাকে একটা
it is
xerox
submitted on behalf of the state respondents
xerox করা আমাকে
that
একটাই আছে copy।
opinion of the requiring body has been sought by the district magistrate in order to ascertain whether the entire stretch of land is intended to be purchased by the requiring body. Paragraph. My learned counsel seeks further accommodation to comply with the order under contempt in its entirety. Paragraph, let the matter appear under the same heading on 20th September.
Yes,
Should be sufficient.
Item number 7.
In this matter, my lord, due to the PLRO's report, my lord, there is some delay. But after that, my lord, we have already issued 10-1 notice to the encroachers.
20.
In this case, my lord, there is only one respondent who encroacher in the, my lord, after inquiry, it was detected that 6 persons was there. So, my lord, we issued notice to 6 persons, all the persons. And so I pray, my lord, 1 month time to give the final compliance, my lord.
Because it's in process.
Affidavit of service.
Affidavit of service. Paragraph, it is submitted on behalf of the alleged contemner that upon receipt of the report of the demarcation report submitted by the Block Land and Land Reforms Officer, notice upon under section 10(1) of the West Bengal Highways Act 1964 has been issued upon 6 encroachers. Stop. Learned counsel seeks 1 month.
Yes, my lord.
A month's accommodation to comply with the order under contempt in its entirety. Paragraph, let the matter appear under the same heading on 20th September.
Yes, ma'am.
So that the process is complete. 2-0.
In the meantime, তোর কোনো চিন্তা নাই।
Feeling better, my lord, or
Yes,
feeling better or decreasing?
I'm talking the whole day, no?
That
Voice needs rest.
That is difficult. Hot water. Grateful to water.
Yes. Item number 8.
In this matter, my lord, already complied with. My
Complied
lord, this check
8, I'm appearing for the petitioner, my lord.
complied.
And they have complied with, Lord, give me a copy of the compliance report.
Complied টাকা পেয়ে গেছে।
Affidavit of compliance.
Kindly, my lord, next week, my lord, file, my lord, kindly record the checks numbers.
Affidavit of compliance. This has to come by way of an affidavit. It's a contempt application.
My lord. Kindly apology, my lord.
Paragraph, it is submitted on behalf of the alleged contemner.
কালকে আজকে দিয়ে গেছে।
It is submitted on behalf of the alleged contemner that the order under contempt has been complied with. Stop. Learned counsel for the alleged contemner seeks to submit an affidavit of compliance on the adjourned date. Paragraph, let the matter appear under the same heading on 31st August. Please serve an advance copy.
Item number 9.
Also, this is my affidavit of service. Finance department.
My lord, in this matter, my lord, I have complied, I am the contemner, I have complied. My lord,
Finance department.
I sent the,
Affidavit is not ready.
yes, my lord. Yeah, I have handed over the copy of the, my lord, affidavit.
Also,
is
I am
ready,
praying
but
for
only
only
the-
last page of the affidavit of compliance.
Affidavit of compliance is not filed.
In compliance to the.
না, সেটা এখনো, my lord,
It's not ready. Please
Also,
come back with
kindly consider my page.
affidavit. Let him come back with the affidavit of compliance.
তোমাকে ওটা দিয়ে ইয়ে করতে গেছে, অ্যাফার্মেশনে গেছে।
It's not ready. I'll give you a short date.
My lord, your lordship fix a short date.
Learned counsel for the alleged contemner submits that the order under contempt has been complied with. Stop. He seeks to file affidavit of compliance on the adjourned date.
তোমার কোনো চিন্তা নেই।
Paragraph, let the matter appear under the same heading on 25th August, next Friday.
Item number 10.
My lord, I am for the petitioner. My lord, on the last occasion, my lord, give me liberty to file the exception to the report. And I have served them, my lord, on the 11th of August.
Who is appearing for the respondents?
Joey Maiti, my lord, for the state. The service.
You have served?
Yes, ma'am, service. 11th of August. my lord.
Miss Joey Maiti. Where is she? Who is she?
My lord, they are admitting our case, my lord. And in the report, my lord, they are also saying that we are trying to take several steps, but due to the act of the government, my lord, we cannot take steps.
Miss Maiti, I find from the record that she chooses to appear when she feels like. Please continue with the hearing.
My lord,
Continue with the hearing. Let me
Ma'am.
pass it on.
my lord. My lord, in this
What is
matter,
the
my lord,
matter about?
well, in this case, my lord, the petitioner is a pharmaceutical company, my lord. And my lord, may I, with the report, it is going, in my exception, if the report is going with lordship's report, their report it is.
Oh, you have given the report? No.
No,
sir.
no, only. My lord, this company is the pharmaceutical company, my lord. In 1981, my lord, this company get a lease from the government in 1981 for preparation of or making of a chemical industry. In the year 1981, they are applied for the same, but in the central government, my lord, but from the pollution board, they are not getting the permission for the same. Next, my lord, they are from up to 1981, they are trying several application made to the authority that we are going to establish the same. And they are in the report, my lord, it is found that they are also trying to approach to the authority for preparation of the tablets and saline water, but it is not issued by the government, and they are not giving the permission. Thereafter, the petitioner trying to set up an agro industry, my lord, in the said plot. That is also not permitted by the government, and they are wrote letter to all the authorities concerned, my lord. I am annexing in the writ petition, and also to the ministers, but they are saying that I am taking care of your matter, but the matter
has
is
been
not
done.
taking step. In the 2009, my lord, the petitioners, the concerned authority, my lord, send a letter that you have not taking steps according to the leasehold. You are not set up any construction over there, and not starting up any company. So we are taking back the land. The petitioner moved the writ petition before this honorable court. After filing the writ petition, this chemical industry got the status quo order from this honorable court. And after that, my lord, the dictatorship has changed twice, and the new government has been come. The petitioner made representation before the new government. They are saying that as the matter is pending before the honorable high court, we cannot approach. So you file a new application along with the proposal plan. So that new director has been filed. Though after that, in 2017, the company again, my lord, the Urban Development Authority has again told that you have already the petition has withdrawn. So we are again entering into the matter. Now, my lord, the petitioner again filed this writ application. In the meantime, petitioner already get all permission from the central government, and my lord, all permission from the all concerned authority. Now there is a start in my reply, my lord. I have in my reply to the exception, my lord, I am annexing that the central state pollution board permanent authority enlistment, but my lord, the page.
Your allotment has been cancelled.
No, it is, they are saying that it is cancelled, but we are in the initially 2009, they are saying cancelled. We challenge that before this honorable court. Honorable court passes order of status quo. There was already set up an industry of tribunal. There is a chemical industry already there. They are starting their production in the said plot. And the matter during the pendency, my lord, the new proposal has been, my lord, in the writ petition, my lord, itself. In page, my lord, 62 of the writ application. And my lord, 61 is the order passed by this honorable court. Honorable court, after hearing us that we are trying our level best to the concerned authority, and it is found from the report itself that all the occasions, my lord, we are trying our level best, but authority did not give permission. And they are already construction done by the company. And 61 is the order of status quo, my lord. Thereafter, petitioner make a proposal before the concerned estate manager. And my lord, 63 is the project profile, page 63.
Yes.
My lord. Next, my lord, the petition, the concerned director wrote letter to the advocate, my lord, page 72, that the amicable settlement is going on, so withdraw the writ petition. Page 72.
This is the earlier writ petition.
Earlier, in the case of earlier writ petition. Next, my lord, page 74. As they directed that as the matter is pending before the Honorable High Court, so we cannot do anything. So, my lord, page 74, as per their direction, my lord, the certified copy of the court's order as everything is submitted by the director of the company. Page 74. And next, my lord, suddenly, my lord, they are in 78, they are saying that as there is no direction from the Honorable High Court, so we are again re-enter on the basis
Matter
of
was withdrawn.
my lord.
Matter was withdrawn pursuant to their request. The
Yes,
earlier
ma'am.
writ petition was withdrawn.
Yes, yes, ma'am. The order of withdrawal, my lord, in page number 77. A written instruction of the director is also submitted before this Honorable Court. As per their direction, they are saying that there is a pendency of the writ application, so we cannot go through the way, so we withdraw the same and we can proceed. After that, my lord, again, they are saying that if there is in page 78 next. So they are saying that 2009 was the notice of 2009 was now in force, so we are again re-entering your property.
Double standards.
My lord. One type, my lord, in the one hand, my lord, state is saying that industry is necessary. They are doing everything from the first to last, from date wise. Now they are saying that. Thereafter, my lord, then he filed a
No amicable settlement was arrived at.
no. It is their direction. They are doing everything now. My lord, next page 79. My lord, this is the reconsideration. They are making authority. The director of the company again file an application for reconsideration. On the other hand, my lord, we have filed our supplementary affidavit. We are praying that, my lord, as per their direction, we have done everything, one step by step, because the construction is there, my lord, everything. In the supplementary affidavit, my lord, we are annexing that we getting the, there is a plan, they are taking charges for more than 38,000 water charges for the, our municipality. In the supplementary affidavit, my lord, I have annex. One supplementary affidavit, my lord, is there.
Yes.
The urban and municipal department are same department, my lord. And the municipality is taking the water charges, my lord, they are in the enlistment certificate is there and they are taking taxes regularly. And the production is going on from the said factory. And if, my lord, we are going through their report also, my lord, they are also saying their report that every occasion from the 1980, my lord, we are trying to set up different companies to them. From in their report, it is evident, my lord, if my lord goes to their report, my lord.
What is this 2017 letter that you have challenged?
My lord, we are challenging 2017, my lord, page 70. That they are again, as the High Court order is not there,
So
so
that letter.
that we have challenged.
So
Page 78, my lord. We are praying for set aside, my lord, that order, and my lord, we are trying to construct, already there is a construction, my lord, we are giving proposed plan, we are giving every details. And
What does the report say?
report, my lord. In the report, my lord, from the paragraph 2, my lord, it is says that from 1980, if going page 2, paragraph 3, my lord, from the 1980, my lord, they are trying to tablet and capsule, but it is not, the government is not giving any, my lord, suggestions. Thereafter, my lord, the agro industry, thereafter, they are trying to produce, my lord, saline water project, which is not entertained by the government. They are trying to set up one after another, my lord, industry over there. It is admitted, my lord, we are trying to make approach before the authority several occasions with proposals.
They have made out a different story in the report.
Yes, madam. In the story, in the report, my lord, they are saying the land was allotted in 1980 and remain unutilized up to 2005. But my lord, they are not, we are stating in our application from the 2010 application also that they are trying to establish, my lord, the pharmaceutical company, which is not allowed by the concerned authority. It is not denied by the concerned authority any occasion. Even, my lord, the petition approach before all the minister, including chief minister, from the concerned office of the chief minister, my lord, they are written that they will take necessary steps. And only one thing, my lord, I am differing from this report, my lord. They are saying that there was a vacant land, but my lord, if there is a water charges, my lord, they are taking enlistment, land is there. So where 38,000 water charges in a vacant land, my lord? This is only differing from them, and they are saying in the my lord, report that page 4 of the report, under heading 11, that we are again praying an application for NOC before the estate manager.
Passing an order in absence of these, the respondents will really not serve your purpose.
Well, we are just praying that set aside the order, my lord, the 2017 letter, and they reconsider it, my lord. Because, my lord, in my reply, my lord, I have annexed an R1, which they are not annexing in their report. We are annexing everything to the estate manager because my enlistment, now their central government gave permission to produce the medicines to us. We are already, there is a production of medicine more than 18,000 of bottles per year. The government of India has already gave permission, municipality gave enlistment, everything. Now the dispute regarding the land.
They say that all these was obtained after the land was resumed. That is their case specifically.
Well, initially they are not giving any permission. Now already all authorities giving us permission.
Yes, but validity of the permission when the land has already been resumed in 2009.
Yes, but thereafter it is status quo. We have challenged that. Though we got order of status quo from this Honorable High Court.
Means resumption stays.
That time the construction is there, man. And construction is already there, man. Production is already there. Water connection and sub connections are giving later on. But the construction is there already.
Yes, and a blanket order of status quo was passed. The order of resumption was not touched.
No, the interim order has been passed.
Yes, and then it was withdrawn. There are anomalies. Let me do one thing. I'll record absence of the learned counsel for the state, and I'll serve a notice upon the office of the GP requesting, I'll record that.
Mine.
Appointment of some other.
Mine.
She doesn't appear to be interested.
Mine.
Or can I request someone in court to appear for the state?
May I hand over Mr. Dev, my lord, the case, all the details.
Mr. Dev, the person who appears, doesn't choose to appear. When she feels like she comes, when she doesn't feel like she doesn't come. So I would like to change this run bit. Please, may I request you to appear? I'll record it.
Yes, ma'am. I mean, be with you. Proceed.
Affidavit of exception submitted on behalf of the petitioners is taken on record. Paragraph. That appears for the state respondents. Stop, no accommodation is sought. Paragraph, it appears from the record that learned counsel appointed for representing the state respondents chooses to appear in this matter only according to her own whims and fancies. Stop. Considering the conduct of learned counsel, this court is inclined to hold that learned counsel is not interested is no longer interested in representing the state in this matter. Paragraph, Mr. Dey, who is present in court and usually appears for the state, is requested to represent the state in this matter. Stop, his appointment be regularized by the office of the learned legal remembrancer instead and place of the appointment of Ms. Joey Maiti. Paragraph, the petitioners are directed to serve copy of the writ petition along with all annexure thereto and the reports
Everything, my lord.
to Mr. Dey in course of this day. Paragraph, let the matter appear under the same heading on 5th September.
A short date may be given as because my lord, he wanted to
5th
reconsider the
September,
order.
5th September.
My lord, he wanted to reconsider
The prayer.
prayer, my lord.
Very well, 25th August, next Friday.
Yes, my lord.
Please give him the copies in the
By
meantime.
Monday, my lord.
Item number 11, my lord, I'm for the petitioner, my lord.
Yes.
On the last occasion on July 20th, my lord was pleased to direct them to file an affidavit.
Yesterday, 11 matters
Madam
were
Shesh
taken.
Kureni?
So, my lord, that was being kept on 30th of this month, my lord, because we were supposed to file up a report, my lord. I asked for a 1 week
Wanted to
more.
come back with a further report.
Yes, my lord, that was a report to be submitted. So, yesterday, 11 matters were there. 30th, the matter has been fixed.
Please ensure that the report is specific to the.
Yes, my lord, I'll be very specific to that, my lord.
You have to disclose the date of depositing the award as well as taking the date of taking.
On,
possession.
my lord has asked them to discuss only 2 points.
Yes, I've stated that in the order.
Yes, my lord, it is there in the order.
But some of the things will come out, my lord, apart from that, what is the thing they have done out? Because they made out an application not to the metro rail. They
When
made
the
out to the
argument is
they made out to RVNL. They came out to the RVNL. That facts have to be brought out, my lord.
But then in that case, my lord, they need to disclose their facts, affidavit in opposition. But my lord, on the last occasion, what happened? They have taken out a point of maintainability. That is why my lord was pleased to direct them to disclose these 2 points only. Now, my lord, they are coming up with new story.
Something has to be brought out because.
But let them file that that affidavit
when are the other matters fixed?
on 30th of
30th of this
So let
month.
this also. appear
Yes,
on
yes, my
30th of
lord.
August.
That can be kept on 30th, my
Item
lord.
number 13, my lord, I am for the respondent.
This is 11. Let me call one by one, please.
Now, what's it? From number of 1830.
A learned counsel for the Metro Railways seeks extension of time to submit the report as called for. Paragraph, let the matter appear under the same heading on 30th August,
Yes, 30th.
2023.
My lord, may it come along with the petition number 114444 of 2020 because
It's already appearing on that date.
Because 11 matters were yesterday, today there are around 6 matters.
may I hand up the Earlier order, my lord.
Not necessary, it'll appear.
Fine.
Altogether 17 matters are there. Yeah.
দিয়ে গেছে নাম্বার কালকে কিন্তু আমি জানি এটা পরের নাম্বার হ্যাঁ হ্যাঁ। কার কাছে দিয়েছিস সেটা দেখতে হবে দিয়ে গেছে কালকে ইয়েস নেক্সট
Item number 12, a similar order may be passed in there.
সিমিলার অর্ডার
Yes, my lord.
Man,
Item
11 to
number
16, my lord. 11 to 16.
11 to 16, my lord, I believe.
On 13,
ইয়েস
I'm,
সেম অর্ডার
I'm filing my report in the form of affidavit.
ইউ আর অ্যাপিয়ারিং ফর
Copy may be
Respondent
served.
number 2. Respondent number 2, I'm filing the report.
Copy may be served. Copy has not been served on.
12, 13, 14,
13 টা
13.
13. 13, this is my. দিলাম। সই করবেন না করবেন না।
কোনো অসুবিধা নেই।
do you need to use an exception to this
My lord, kindly give me that liberty. If I find anything, then I'll file my exception.
I have
and
served
let
a
it
copy.
appear on the same date 30th
Yes, yes,
August.
my lord.
Yes.
Within,
Similar matter
yes, on 30th, my lord.
the issue is the same
Same.
Same.
report in the form of affidavit submitted on behalf of the respondents is taken on record. On behalf of the second respondent is taken on record. Paragraph, on prayer of the petitioner, liberty is granted to use an exception to the report, comma, if required. Paragraph, let the matter appear under the same heading on 30th
এটা
August.
বোধহয় আপনার copy.
This will appear on 30th.
30.
30th, my lord.
My lord, item now 14, 15, I believe.
14,
Same order.
All on.
Similar order as item number
Because
11,
we were to suppose to file a
11 and 12.
14, 15 and 16, my lord.
অসুবিধা হয়ে যাবে।
আগের
14.
টার মতন same order হবে। হ্যাঁ।
14, 15,
My lord,
Till 16.
Till 16, my lord.
16.
Lordship, in 16, I'm appearing on behalf of the respondents. I will file the report on the next occasion, Lordship. Report is already ready. It's need to be affirmed,
You are not
Lordship.
appearing in 16.
my lord, I'm appearing, all have been in the last order, it has been given.
No, Lordship, last occasion, there was several matter. He was appointed, but 16 was appointed by Mr. Rahul Sharka and Deepika
Yes,
Sharka.
yesterday my lord has corrected that the Union of India and Ministry of Rail. অমুক অর্ডারটা দাও।
The metro
আচ্ছা,
authority
আচ্ছা, এখানে
says it's the same.
My lord, the Union of India is different, the petrol is different.
আমার
But
নামটা
yesterday.
Your submission was just
But
the opposite
what has
yesterday.
happened, the merger of the Ministry of Law and Justice and the railway people had come out together to appear out on a single lawyer. They came out with this notification in 22. But both have their own identity.
For whom are you appearing?
Lordship, in this matter, I'm appearing on behalf of Metro Railway. I have the instruction. I got the instruction yesterday also. The personals are standing over there who instructed us on behalf of the Metro Railway, Lordship.
Fight it out outside the court.
Yes, Your Lordship, I will file the report on the next occasion.
This is the yesterday's order, my lord.
Report has not been filed in this.
No, my lord. Report has not been filed yet. That was the correction made yesterday on the same.
In the advocacy.
Yes, man. But my lord, only thing that they need to serve the.
Yes,
copy
Lordship,
of
I will
them in the
definitely
meantime, so
serve.
that
Yes, Lordship.
in case of any
Um,
exceptions required, we may file that.
16 and Lordship. Learned counsel for the respondents.
সার্ভিস করলাম।
Seeks
আচ্ছা, আমার
extension of
পিছনে
time
কাগজ দিন।
to submit the report in the form of
বললো।
affidavit
করেছে।
as called for. Paragraph, let the matter appear under the same heading on the 30th August. Same.
March.
Item number 17.
My lord,
Yes.
the land was acquired in the 1990. My lord,
90.
1990 till date, the possession has not yet been taken. During the apportionment, dispute of apportionment, section 30 application was filed before the learned the district judge. Kindly see the order page 45. 45 order start, operative portion 48. The LA case number such and such is allowed on contest. The prayer for apportionment of the compensation is allowed under section 30 of the LA Act in terms of the joint petition dated such and such. Let the petition be made is a made part of this award. On an earlier occasion, your lordship directed me that this petitioner are the petitioners before the Lale district judge or not. I obtain a certified copy. Kindly see this is the petition which was filed.
The same petitioners.
But this is the petition, my lord, section 30 petition, Lane district judge, which was disposed, my lord. My lord, page 2, my lord, the petitioner's name, my lord.
So what is your grievance now?
Now grievance is, my lord, that the state has not yet taken possession. Your lordship earlier occasion directed to submit a report regarding, my lord, either, my lord, hand over the land, or, my lord, the no award has been passed, or, my lord, deposited in the court, my lord, then, my lord, either, my lord, 24 of the, my lord, a new act, my lord, compensation can be, my lord, issue, my lord, in or as per provision of section 24(2) of the Act, my lord, Act 13.
Nirmal Kumar Shaha is the petitioner here.
Yes.
এখানে না এটা এর সঙ্গে ছিল অসিত 6
So you're seeking implementation of this order.
No, my lord, but there is, my lord, the implement though, but, my lord, the state is not yet taking possession. LA collector, my lord, they hand over this land. But till, my lord, I am in possession.
Award has been declared.
But as per
Which
section,
apportionment-
That proceedings has been initiated under Act 2, 1948. During the matter time, when it has not been completed. Thereafter, 93B is notice issued. It has been, completed after passing award. Thereafter, it has been detected, there are several landowners, accordingly, section 30 has been applied.
And section 30 has been.
Section 30
disposed of.
decided by person under district judge.
Yes.
The amount has been deposited to the treasury. Then the possession has been taken over. Now they have preferred an application before the page 50, my lord, under section 18. That is pending also. Reference. Now they are claiming it will not be acted. Section 24 to be applied.
Section 18 is also pending.
Pending.
section 18,
Page 50.
Admitted. They have preferred application. পুলিশ রেকর্ড That will be decided, my lord, at the London district. LA judge.
well, that
Yes.
It is admitted position. Award has been declared possession.
So after
taken
this,
way
what are you
apart.
asking for in this?
But this is not possible. This is
that-
not maintainable at all.
no, that proceeding, my lord, section 18 proceeding will be disposed of.
Is that your prayer? Withdraw, sir.
Well, your lordship is a bold up
No.
here, my lord, it's a
Ah,
section
that is
18
not
proceeding.
possible.
There is no reference to section 18 at all in your writ petition.
But the authority, my lord, not yet, my lord, deferred this.
না না আমাদের টাকা জমা দেওয়া আছে এটা 18 না হলে আমরা দেবো কি করে 18 ডিসপোজ করে দিয়ে দেবো আমাদের না দেওয়ার কোনো অসুবিধা নেই।
Yes. And your prayer is for initiation of land acquisition
Hello.
proceedings
That is not possible.
after section 18. Is it possible? Under the law?
Then withdraw the petition and liberty may be given to file a fresh after disposal.
File afresh on this ground?
No,
Not
no.
necessary at all. Just let it withdraw. You have a fresh,
Complete of that.
you'll have a fresh cause of action. I don't think you require to file a fresh writ petition on the same cause of action. Not necessary at all. Isn't it?
Yes, yes.
So no liberty is necessary. Learned counsel for the petitioner seeks to petitioners. Petitioners submits that the petitioners do not intend to proceed with the writ petition any further. Paragraph. In view of the same, comma, the writ petition being WPA such and such is dismissed for non-prosecution. There shall, however, be no order as to costs as is certified website. You can take this back.
Item number 18.
18, I am appearing for the writ petition.
Respondents?
Mr. Bhattacharya was representing.
With your lordship's leave. Not very short point.
Respondents?
Mr. Bikash,
For the
Mr.
respondents.
Bikash Ranjan Bhattacharya had appeared.
Yes.
These,
There were others also.
Lord, may I just, there's an order of 23rd February.
Yes.
The fourth paragraph, learned counsel for the respondent number 2 seeks to file a short report annexing all relevant documents in this regard. Lord, the ground which I had urged while moving was that there is an order of the competent authority, Metro Railways, rejecting my objections on material which was not supplied to me. And the order records that I have come to learn of X, Y, Z. Now, that's not given to me. That's not part of the court record. So therefore, on the basis of private communication, I'm not alleging malafide even once. We had a very fair hearing. We had an extremely fair hearing, but relying on information which is otherwise available because the metro officials are there to assist, my matter cannot be dismissed. The same material should be given to me, and then I must be heard on it.
Not as an opportunity.
Yes, this what passes through the learned judge's mind. If I on material, if that has to be argued in court so that I can object to it, and the material must be given to me.
So will you do one thing? I'll fix another date.
Yes, my
Because
lord.
on the earlier date also, there was no one for the respondents. They were not represented.
I'll tell Mr.
Will you
Bhattacharya.
serve a notice?
I'll do that, my lord. My lord, would your lordship keep it, my lord, next Friday?
Very well, come back.
Next Friday, my lord.
None appears for the respondents. Paragraph, let the matter appear under the same heading on 25th August. Paragraph, the petitioners are directed to serve notice upon the respondents intimating the urgent date.
Grateful.
Item number 18.
18.
19.
19.
Papers. What is this? Second round writ application. The first,
Respondents.
And for the state?
when National Highway Authority, my lord, acquired the land of the petitioners, since compensation part of compensation for the left out structure was not paid, then we came to the Supreme Court. Your lordship's order was is, or kindly see page, my lord's order, page 56. An advocate appearing where the petitioner draws the attention of the court to annexure page 16, appearing page 69 with this petition, which is document
or estimate issued to the competent authority for compensation of acquisition of land or the national highway such as for missing structure. He also submits that no compensation amount has been received by the petitioner till date. That advocate appearing on behalf of the National Highways Authority of India in short NHS service, the entire amount stated in the said document has been deposited with the competent authority. Accordingly, the petitioner is liberty to file an application before the respondent number 2 within a period of 2 weeks for the data disbursal of such compensation amount in his paper. If such application is made by the petitioner, the respondent is right to consider and dispose the
This
application.
has not been complied with.
No, missed out structure that has not been copied. Kindly see your losses, kindly see. Your losses, but our application has been rejected. But kindly see page 55. Now, prior to that, your losses, kindly see, prior to that, just a minute. Page 52. This amount was sanctioned. Page 52, sanction amount.
Yes,
Have you got it?
yes.
Then, my lord, can you see page, prior to that, page 50? Page 54. This is a letter of additional land acquisition with the competent authority to the project officer, the director, National Highways Authority. Submission of estimate for left out structure of Monja such and such. The 3G estimate of left out structure is being sent to his end for placement of the fund. Then this was that amount was awarded. Then, my lord, next, that was email, by email, but that was informed to the petitioners, my lord. It is, please refer to training email. It is informed that the supplementary 3G estimate for your left out, supplementary left out structure is in process for approval of the competent authority. The fund will be deposited to CL Nodia upon approval of the competition authority. No whisper, that has not been done. That is my submission before lordship. That is the left out structure that has been determined. Now they are saying, kindly see the impugned order. Impugned order. Page, my lord. Internal page 64. Not internal order, page 64.
Yes.
But I am not reading the entire order. All the above documentary evidence makes it clear that the packaged drinking water was distributed. All for packaged drinking water that was on the land. Such and such. Regarding preparation of 3G estimate against left out structure, it should be reiterated. And it was done as a process of land acquisition completion thereof. All the communication made in this regard are part of determination of eligible content of compensation only. It should not be construed as the acceptance of any unqualified, unjustly free of compensation. It is crystal clear. The applicants is such and such receive both award main and arbitral, along with structural compensation, along with exercise such and such. In respect of structure constructed after publication 3A notification, any study such as that. The court, as per the order of the court, opportunity of being was given to the such and such, but the applicant refused to attend under such a state of affairs. The undersigned, being a creature of statute, is not in a position to disburse any compensation against the structure constructed by piece of land after 3A notification. My submission, my lord, that structure was made prior to 3A notification. Anyway, my lord, the left of structure they have determined. Now they say they produce the document that has been paid to my client. Some that has been deposited, but a supplementary. That submission was made before your lordship other day, and National Highways Authority stated that amount has been deposited to the competent authority. That is my submission.
Yes.
May I clarify, my lord? In this case, my lord, we have complied with your lordship's previous order by calling him for a hearing. He did not appear, saying that contempt is pending. We passed a reasoned order. The sum and substance of the order is that award was given, main and arbitral award was given. He has appeared and accepted that award, which contains the land as well as the structure. After 3A notification, some constructions were made, which he is not entitled to, that has not been considered in his favor. So what he has received, that is the amount he is entitled to.
What about your earlier communications?
Now, my lord, regarding this adjudication, my lord, adjudication,
After that is 2019. After that, it has been considered and award has been given. So only remedy before him, if he is dissatisfied with the quantum, is under section 34 of the Arbitration and Conciliation Act, because the provisions apply. Unless he challenges that order,
Satisfied with the quantum at all. He has received the original award with regard to structure and land, no
land,
dispute.
yes.
Additional structure, the subsequent structure part, he says he has not received. And these documents say that you have admitted it.
Which document?
That is document.
Page 52,
Your document,
54.
page 54. Page 54.
My brief is very badly paginated.
The next email also.
52 is the original award, not the.
You say, I have no dispute. We are not
Yes.
disputing. They have stated
It has been
that has been
ascertained
determined.
that the structures have been constructed after 3 capital A. Even if there is some structure, if the authority comes to a factual finding that the structure is after 3A, then he is not entitled to it. Matter might have been considered by the authorities, but ultimately the arbitral tribunal has come to the finding that the structures are not part of the prior to 3A notification. So this is a disputed question of fact. Now he is disputing that. What is the forum for such dispute, my lord? He will have to challenge that before the section 34 court. It will be purely a question of fact. We do not say that yes, you are entitled to additional structure. There are left out portion.
That has been determined.
No, it has been considered.
And national has with
No,
already
not a
deposited
determination.
with the
Award
authority.
is the determination. In the award, it is determined that he will not get it. Now, if the determination is incorrect, he will have to go before the appropriate forum under section 34. Can he now say that the award was bad in a second repetition?
I am not saying the award is bad.
Then
I am not saying.
he cannot start a second
I am-
round of adjudication.
I'm asking for that money, that amount that has been determined.
It has to
National
be
has
asked for in the
deposited.
proper forum.
What is the proper? I am not
34 is the proper forum.
challenging.
354.
My lord.
54.
53. কোথায় 53 কি ব্রিফ দিয়েছো উল্টো পাতা সব লাগানো
The original award was in 2018. After that, in page 54 is 2019.
yes
Yes.
And you have decided to pay the amount to him.
কি করে করছিস রে? তো একটা কপি দে তো। তোমার একটা কপি দিতে।
The estimate was
Left out
submitted
structure.
to,
No,
NHAI.
now my lord, if the left out structure, if it is ultimately found that the structure is constructed afterwards, then how he will get it,
So
my lord?
this was before it was found. The amount was decided, estimate.
The award was given, my lord, by not taking into, he is saying that it was not taken into consideration. Now, if he is aggrieved by,
54 deals with only the left out structure.
I say,
He
my lord,
thinks that it was decided that there is a left out structure for which the petitioner is entitled.
I again humbly submit, my lord, if something is left out, it is part of the complete package. He cannot get, my lord, in piecemeal, in two separate proceedings. If something is left out, his only remedy is in section 34. My lord. If he misses that, my lord, kindly, my lord, they cannot start a second round of adjudication.
Arbitral award.
Arbitral award, award, my lord,
Not included in any award at all. Subsequently, you have said that he is entitled. Please come to page 54,
54 says that some portion is left out. Now, my lord,
It's
true,
clear.
some portion is left out. These structures were not considered. What is the reason of non-consideration? Because these structures were raised after the 3A notification.
Where is that stated?
That is the not reason order. That is the finding. It has been
How have
specifically
we
found.
arrived at that finding?
We have not challenged that order. We have not challenged.
Kindly see,
But
Lord,
since
kindly
that was not paid to us.
come to page
Hey, we
63.
came to
the order.
your lordship and they national has already submitted. We have deposited with the
Kindly allow me to
authority.
place the impugned order, my
They
lord.
can review his own order. We are not challenging.
Verification of
review.
documents, may I place?
The relevant
Ma'am.
portion.
Page 63, my lord, on verification of documentary evidences available at this office as findings are as detailed below. Notification under section 3A of the National Highways Act was published on 15/12/2009 by declaring the intention to acquire several plots of Mauja so and so, including subject plot. Subsequently, declaration as per 3D was made on 26/8/2010. Eventually, compensation against acquisition of 1574 acre of land and structure was duly paid by the competent authority, and arbitration award was also received by the applicant. Srimati Mamata Nath submitted several petitions to the competent authority, which are of identical stake. All the representations were duly reciprocated by the competent authority from time to time. It is crystal clear from the correspondence made to Srimati Mamata Nath, file number so and so, that the packaged drinking water plant was established after 3A notification, that is 15/12/2009. Several other correspondences also corroborate the same. It is very much on record that the NHAI and land acquisition authorities have then
Hey, Baki, please.
nothing is available. After
Other
that,
lines are not there.
So, my lord, they have
What a
come to a
poor
factual
copy have you
finding.
given.
Your lordship's order was there, kindly see my lord's previous order. My lord's previous order, page 57. They submitted, they deposited. We are not disputing the amount.
Your lordship didn't
That is
My
their
lord,
order.
decide anything,
But
only
had
to
it been the
consider.
case, if that amount was paid to my client, the petitioner would not have moved any rich application. According to the petition, debated to file application with a period of 2 weeks from the date of disbursal of such compensation amount.
Yes.
They have submitted.
Your lordship didn't
submitted
decide
any-
on merits.
We have
It
deposited.
was
that is
left to the
our
authorities to
amount.
decide.
What
My
now
lord, it
saying?
is,
No,
No, no, no.
we shall not pay. That means that order has been reviewed. The recall. Suo moto.
The earlier order also
There is
says the
recall.
same thing. It was the submission of the authority, both the state and the NHAI,
My lord.
that he is entitled to the amount and that has been, the estimate has been there, given.
They have not challenged that order.
this
Lord,
estimate
your
is
lordship.
entire for the Mosa, my lord. It is not only for my learned friend, the client, my lord. This is entire Mosa.
Yes. Entire amount.
Entire
stated.
amount, my lord. This amount is only for the entire Mosa, my lord. Whether my client, my learned friend's client is in under the zone or not, my lord, that will decide by the competent authority, my lord.
It has to be decided. Your lordship didn't decide that he is entitled. Your lordship only recorded that entire Moja compensation has been deposited. Liberty was given to him to apply for the additional compensation. He has applied. We have considered and passed a reasoned order, my lord, on which categorical factual finding is that the construction is after the 3A notification. Now he will have to refute that. Then kindly allow me to file an affidavit. Let him refute that, because I say it is after the 3A notification.
And
On-
the petitioner did not appear before the authority when the hearing
No.
was done.
No,
Right?
no, no,
No, no,
no.
Why?
Since we took out a contempt application, within time, they have not disposed of the representation which came. But your lordship cited to sub-copy.
This
The matter is, that is why he
Does the contempt application preclude the
canceled
petitioner
that
from
was
appearing
pending.
before it?
During pending is the contempt application, there is a direction that is anyway, my lord,
That is what normally happens.
that he ought to have. We ought to have attended the hearing. He missed it. Since he was of the view, since the contempt application is pending, I shall not go. But that is that of the view. I am not saying that. But he has done mistake.
There are
He
other
can see.
documents also which are considered. Kindly come to the
But my client, if you also
building
give
plan.
liberty,
for-
just a minute. If you also give liberty again, then my client can appear before the authority concerned again. Because he's a contempt petition, he was of the, he shall not go there. That is the reason.
Will you reconsider upon hearing the
Well,
petition?
that we shall, my lord, because the documents were also considered. The building plan of 2010.
I've seen that, I've seen that.
The documents have been considered. Okay, he cannot get something, my lord, by virtue of one.
That is your order. I do.
Whatever lordship directs, my lord.
The additional structure was
No, no,
admittedly
no.
after the three notification.
He has not.
So then how are you entitled?
But
Yes.
the amount is determined.
My lord, that amount is determined in terms of the entire
Say,
Mosa.
my learned friends can file an affidavit, say that amount has been paid. Kind of only that was.
The entire amount of compensation.
No,
has
that
been
is not
paid.
entire amount. What is page 52, that is only for the petitioner.
Entire Mosa.
Entire amount.
Page 54.
Your lordship's order recorded the entire Moja.
Oh, no, I am not saying that.
LA case number and the entire moja.
Yes, entire Mosa.
Entire moja. There is a, it is entire
Left
moja,
out
that is amount.
structures of the entire moja.
Exactly.
Please come to page 54.
But that is also, page 52 also entire moja.
Yes.
But can you ask them to file a report? But
Yes.
I shall give it. Can you ask them?
Report is
I
not
want to
necessary.
put it-
No. Can you ask them?
Say the same
You are only
thing.
making service. I am saying that not entire moja.
Substantiate this point. Because all the documents say entire moja. Where is it stated that it's only for the petitioner that it was estimated?
This is a Momotana, deed of compensation.
Estimate of for left
Page
out
53.
structures.
Page 53.
Page 53, that is the letter to the petitioner.
Yes.
For
That we
president
have
of one.
already submitted an
I don't
estimate
think
for
you
left
can-
out structure missing.
Saying.
তুমি এই page টা দেখো।
It is not in dispute that the structure was raised after the 3A
But I am
notification.
disputing another week, I could not appear. It is admitted.
No. The structures were raised, the structure for which you are claiming compensation now, they were raised after the 3A notification.
My submission, no.
Fund was not replaced.
No, but
Then
that time I saw, I have pleaded in my petition, I have pleaded, there is pleading. What I am submitting, my lord, I can appear
When
today.
have you
Now
raised
give
the
me liberty,
structures?
again I shall appear before the authority
When
concerned.
have you raised the structures?
Prior to that, Malakali page paragraph,
Prior to that means prior to stay notification.
I see, page
Yes.
40,
Yes. Paragraph.
page 13. Just a minute. Yes,
এটা বলো কোডকে দেখে রাখো। Mala, the building plan is in the year 2010.
orders on the which document they have submitted. I could not appear. Anyway, I missed it. I did not make any submission before the authority concern.
I could not appear, it is I did not appear.
No, but I did not.
Deliberately
I
did
did
not
not,
appear.
not everybody. But he was of the view only that is the content of his penny, next day.
Can that be a reason?
Anyway, he has mistake. Through mistake, he did not. That is I am making subject before lost it, but I can give liberty. I shall, my client will appear without making any application. Can he fix it? He will, can he fix it?
If he fix it.
He will make his submission.
Will you do that, Mr. Manager?
Can you pass the direction to that?
Let his client be
Because hearing-
satisfied that he is heard.
Yes.
By keeping it pending or disposing of it?
This is possible.
Yes, yes, yes.
Because that will give rise to a separate cause of action. Heard learned counsels for the parties. Paragraph pursuant to an order passed by this court on 2nd September 2021 in WPA number 2009 of 2021. Granting liberty to the petitioner to file an application before the concerned authority for disbursal of compensation in respect of the missing structure in the plot in question, and a direction upon the authority to consider and dispose of the application in accordance with law within a stipulated time frame, comma. The petitioner submitted an application before the authority on 8th September 2021. Stop. The application was taken up for consideration by the authority on 9th March 2022. Stop. The petitioner did not appear before the authority at the time of hearing, despite receipt of notice, since a contempt application filed by the petitioner against the authority for non-compliance of the earlier order of this court was pending. Stop. By the order impugned, passed on 9th March 2022, comma, the application of the petitioner was dismissed. Was rejected. Stop. The petitioner seeks reconsideration of her prayer by the authority upon granting her an opportunity of hearing. Paragraph. Upon consideration of the submission made on behalf of the parties, comma, this court is inclined to hold that though the petitioner deliberately did not appear before the authority on the date of hearing, despite service of notice upon her, comma, the petitioner be given an opportunity of hearing by the authority and the prayer of the petitioner be reconsidered. Comma, the petitioner be given. The prayer of the petitioner be reconsidered by the authority upon affording an opportunity of hearing to the petitioner. Paragraph accordingly, the writ petition is disposed of. Paragraph.
নামটা কি দিতে বলবো?
Accordingly, the order impute
Complaint authority.
passed on 9th March 2022 is set aside. Paragraph, the writ petition is disposed of, directing the concerned authority being respondent number.
My lord, respondent number 4.
Being the,
4.
it should be the ADM.
No, ADM, he's the ADM, additional district magistrate, LA. ADM, LA.
ADM has not been made up.
Oh, respondent number 2.
2, my lord.
Being the second respondent herein, to revisit the issue upon affording reasonable opportunity of hearing to the petitioner and pass a reasoned order in accordance with law.
All points are kept open, my lord,
Yes, yes.
including the point of the date of the structure, because otherwise.
Within 1 month,
Kindly, can I mention that, my lord, the point of, this point is also kept open.
which
because
point?
The point,
The
the
left of
date of,
structure,
date
my
of the
lord.
structure.
I'll state that I've not gone into merits.
Okay.
Let the
Ma'am,
authority
ma'am,
decide.
ma'am.
But give opposite petitioner or representative of the petitioner.
Can I go on? Affording reasonable opportunity to the petitioner
Acha,
slash her
Hearing
authorized
clear.
representative. Authorized representative. Within 1 month from the date of communication of this order. Paragraph, it is made, paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, it is made clear that that this court has not gone into the merits of the case and the concerned authority shall be at liberty to deal with the issue independently without being influenced by any observation which may have been made in this order.
Much obliged.
My lord, within 8 weeks, my lord.
1 month.
1 month.
1 month, then further 1 week for communication.
Through the affidavit of service. Next. Body record. Next.
Item number 20.
I am for the petitioner. 20.
It's 20 or 19?
20.
20.
19 is over.
To the question of acquisition of property, I required report.
Where is your affidavit?
This is I am filing.
I have filed my report that my learned friend was supposed to file exception.
Exception. There's your copy.
Have you received a copy of the exception?
I have said,
Mr. Taluga, have you
In
received?
opposition of what I have filed report.
against the report.
Against the report.
Should be an exception.
Not affidavit in opposition. He is not well, he was stating that.
It is although it is written otherwise, but the subject matter is the objection against their report.
Anyway, yes, what is the matter about?
Huh?
What is the matter about?
Matter,
Please place your case.
okay, Didi,
Who is appearing for the state?
State's presence is necessary. He is challenging the acquisition.
Yes.
And after several years, 3 decades.
I sought
Mr. Ghosh for the KMC.
KMC.
KMDA is a
State is also there.
KMC is also there.
Shishana
And who is
Bandhavadhyay.
sixth?
Shishana Bandhavadhyay along with Mr. Orko Nag is appearing for the state.
Where are the other respondents?
They should come. There are many points, my lord.
let it,
Let me fix a date.
yes.
Please inform the state and the KMC also.
He should change it. If it
Other-
depends,
The nomenclature is wrong, doesn't matter.
not only the nomenclature, he has also
The heading is otherwise, but the subject matter is, it is a reply against the report.
The contents are all right, no?
Then my lord, kindly record one line. Otherwise, in the record, my lord, it. in
I'll
future,
record, this is
in-
the exception I'll record, yes.
If it has an exception.
Exception used by the petitioner against the report in the form of affidavit submitted on behalf of the KMDA is taken on record. Paragraph none appears for the state and the KMC. Paragraph let the matter appear under the same heading on 5th September. 5th September. Paragraph the petitioner
Exception by the petition.
taken on record.
And it has been described as an affidavit in opposition, only one.
Doesn't matter, doesn't matter.
My lord,
Don't let it be treated as an exception.
my lord, the date we fixed after that, because 15 days required, because I am not physically fit, so fix it after 15th September.
Today is 18th.
Huh?
Today is only 18th.
18th August.
Yes.
Okay.
So you're asking for 15 days. That is 1st September.
Okay.
And I have said 5th September. Yes.
Yes.
After 15.
No. I have the time paying for March time. Okay. I am ready.
Very well. Come back on 13th September next week. 13th quarter. 13th September, Mr. Kalanda.
Item number 21.
Yes.
The stitched judgment, that Puri matter.
I think, my lord, everything, both sides are being only the last occasion kindly. So summarize that my argument, my lord. I have said, I have made a submission. First, no statutory list. No public law evidence is involved. No contravention of the statute. What they have challenged, in my humble opinion, I just took that to speak myself. They have challenged for implementation of a trust, provisions in the trust. But I say that the rate is not maintainable. You can file the suit. Whatever, in order to implement that, whatever provision is there in the trust, you can implement that. For that, you have to file a title sheet before the appropriate court. And my lord, I have submitted first, my lord. This is first, my lord, page. Resolution. Page 12 of the deed. This is the trust deed. And in the trust deed, one of the provisions has been incorporated. That if it is not done, then it will be done by your and the claim or something. My submission is very much limited to that question. There is no public law evidence is being involved in this. And my lords wanted to ask, what is public law? My lord, I am relying upon the judgment of 2000, I am handing over 2006, 10 Supreme Court cases 1. My lord, here, my lord, only.
তোমার কাছে তো একটাই জাজমেন্ট দাদা আমি তো আগে তো দিয়েছিলাম আগে না জজ সাহেবকে
দিয়েছে
From the last commission, I have.
তোমার সেলাই ছিল না
সেলাই ছিল না দাদা, সেলাই।
আমি রেডি হয়ে এসেছি জজ সাহেবকে দিয়ে দিচ্ছি আমার কপিটাই দিচ্ছি আর যেন টাইম না হয় তার জন্য রেডি
I have retired about 2 judges. No, আগের দিন এইটা দিয়েছিল
স্টিচ ছিল
ছিল না,
দিয়ে দিয়েছি
দিয়ে দিয়েছি। আমরা স্টিচ করে দিয়েছি।
My lord, here, my lord, kindly see the my lord is only exercising my lord's judiciary and joint judicial review is permissible. My lord, is a clear-cut final till date. My lord, I am not burdened with, my lord, I do not wish to burden with so many judgments of the recent court. The principle is same. Even the difference between the private law and the public law has not been diminished. It still exists in the legal parlance.
You're referring to
Well,
paragraphs?
here, my lord, 92, paragraph 92.
Yes.
Well, this is, my lord, case, my lord, disinvestment of privatization of government assets. Well, 91st, my lord, page. Paragraph 88, 89, 90, 91, 90. This in final analysis, what Mallet got it?
Yes, yes.
In final analysis, what EGM has done is to accept the report of the EC subject to the validation done by Gate. The extent of 89 paragraph. The extent of judicial review in a case of this nature where the texture cannot be matched with one relating to award of contract, the observation of this contract in Roundup International Limited. It was observed, hence, before entertaining a writ petition and passing an interim order in such a petition, court must carefully weigh the conflicting. This is one of the my lord, judicial thinking, my lord, conflicting public interest. What public judges put that? What public interest they will suffer? Rather, will suffer public interest. State, because we want to make a construction of a youth hostel. So it will serve the public in the better footing. On the better footing, the public will be benefited. But this is not their case. Even for argument's sake, my
case
the public interest.
Public
Only when it comes to a conclusion that there is an overwhelming public interest. This is where I am. In entertaining the petition, court should intervene. Where is, I just took that to, where is the overwhelming public interest? So for this case is concerned. Number two. This view was reiterated in such and such paragraph 90, paragraph 90. Paragraph 91 is the Queen's Bench decision is RV Department Construction Affairs. It was internally held as follows. It is not every wandering from the precise path of best practice that lends fuel to claim for judicial review. Next is very important. Same would be available only if public law element is apparent, which would arise only in case of only. The word only is there, that particular word. In case of bribery, corruption, implementation of unlawful policy, and the like, means analogous to that. In the case of commercial contracts, appropriate view of wandering was noted, such and such. It does not have the material expertise. This is not material so far, which judgment cannot properly be the subject of public law challenge on the grounds of advanced in the evidence before me. So, my lord, what is the point before my lord? My lord, I just again at the cost of repetition that for implementation, so far the writ is concerned, for implementation of the provisions incorporated in the transaction. This is not a registered transaction or registered or the on the basis of statutory deed. Registered, that means if the deed is on the basis of any statute, then yes, they can enforce it. This deed may be registered, but it is in the private realm.
this is not based on the basis of any statute or any statutory provision. Number two, that for implementation, you cannot say that I have got no revenue. You have a revenue. You exhaust it there. Because property is not here, property is minor before the Odisha or Puri, I think. So, the challenge here, can you see? Challenge, there is, what a mind, whatever is there is there. They have relied upon one in communication. After that, kindly consider it has got no statutory value or the basis on which they are relying upon. This is not based on any statutory response. So no public law element is being involved. And public law, and there is no overwhelming public interest, which gives them a favor for enforcing their rights. This is not a statutory right. This is my honest.
That's it.
Anything
in reply?
No,
Public law. Well, I have handed over to your lordship the three judgments. One, your lordship find that is.
Again on the another paragraph 101.
Joseph Pornian, Purutai.
101, these are the
This is settlement of coal gates. This settlement of coal gates regarding the property involved.
Assuming for a moment, in a contractual matter, read life. But to what extent? And let them show one judgment which says that there is no difference between the public law element and private law. Matter ends.
Yes. Objection, my lord, I have handed over to your lordship. If your lordship may kindly consider page 11, supplementary affidavit. For the purpose of, can you recall that it is the government who is enjoying my property with an assurance under section 70 of the Contract Act. The public law element says the legal right and the constitutional right can be washed up by the realm of public law, not that the argument I am anticipating. Be as it may.
Supplementary affidavit.
Yes, page 11, access C.
Yes.
I am directed to refer to your conversation with the Minister in charge of Sustenance Department of Telephone along with the letter that it says on subject, and I have said that the MSA agreed to your proposal. What is the proposal to hand over to your, at the subject matter your lordship find what is the proposal you have made. Therefore, you are requested to take resolution the matter to send the same to the department for consideration. Next page is the resolution which was forwarded by the trust. Now the property belongs to the petitioner. There is no dispute among the same. So now the state government is enjoying my property with an assurance that they will do the same. So as on date or the date on which they have to do. Now there is subjudice. What matter subjudice? Oh, subjudice. Okay. So therefore, my lord, they're enjoying my property on the assurance that they will do this and this work, on basis of which I have given that I am also entitled to benefit of the same. So my enjoyment restricted on the basis of the assurance given by the state or the entire into the contract that you will provide this benefit. But the compensation or the deprivation of the property can be two things. One is by kind or by compensation. This is one thing that this facility will be provided by the government to you, provided you have to give this property to me. That has been done. We have given the property. They have not.
Satisfy the public element.
Public element. Now, my lord, can you consider the judgment as the public element? Public element, my lord, contractual obligation regarding the public element. This is a right of the petitioner from depriving of enjoyment of his own property.
Public element.
My lord, public element, my lord, public element.
Public element is, my lord, kindly consider what is the public element. Public element is the property or the land which belongs to a individual can be taken away by the authority by exercising power of eminent domain.
When a public body deals with
Now, before that, my lord, I wanted to, this is a contractual obligation. Whether the read code will interfere in this type of contractual obligation or not. That's why, my lord, I have handed over to your lordship, my lord, on the earlier occasion, the judgment Property of Venkat Rao Patil versus State of Maharashtra. I have handed over to your lordship, my lord. Paragraph 5, my lord. No doubt, normally when the petition involves dispute question of fact and law, and the High Court would slow in determining the petition under 26 of the Constitution of India. My lord got it. After that, ABL International has been quoted after that. From the above discussion, now the Supreme Court has
Yes.
the following legal principle emerges as the maintainability of a writ petition. Well, got it. In an appropriate case, writ petition against the state or an instrument of the state arising out of contractual obligation is maintainable. Merely because some dispute question of facts arises consideration, same cannot be ground for refuse to entertain a writ petition in all cases as a matter of rule. Writ petition involving the consequence of relief of monetary claim is also maintainable. However, while entertaining an objection to the maintainability of a writ petition under 26 of India, the court should bear in mind the fact that the power to issue prerogative writs under 226 of the Constitution is plenary in nature and not limited by any other provisions of the Constitution. The High Court, having regard to the facts of the case, has a discretion to entertain or not entertain a petition. The court has imposed upon self-entertained restriction in exercise of the power, such and such, and this plenary right of the High Court to issue prerogative writ will not normally be exercised by the High Court to exclusion of the other available remedies unless such state or its interpretation is arbitrary and unreasonable so as to violate the constitutional mandate Article 14, or for other valid and legitimate reasons for which the court thinks it is necessary to exercise the said jurisdiction. Pause here a comment. This is the thing which I am wanted to. You have taken the property by exercising, and this is section 70. My lord, kindly recall section 70 of the Contract Act. I have altered my position on the basis of the assurance given by you. Why Mr. Denning is disturbing me? I'm a petty lawyer and Mr. Denning is sitting behind me. And
Yes, let's see.
now, my lord, can you consider the next judgment which I handed over to your lordship as the Messrs. M.K. Basu and others. It has been upheld to the division bench also.
Before that,
About,
my lord, only latest judgment I am showing.
what this is not a type of
NG project.
I don't know whether reply after reply again argument whether this is part.
Since he says contractual terms and whether it is maintainable.
I'll complete.
You are F2?
That's the judgment of Mr. M.K. Basu and others, passed by your lordship.
I'm sorry to mention, M.K. Basu was passed initially by my lords. I did appear in the before my lords. This relates to catching of fish in the railway colony, and tender was granted. Challenging that cancellation of tender process, we came before this court. Railway and Union of India took this point that since this emanates from the contract, writ petition is not maintainable, and my lord has held, relying on ABL and Jayanti Pal's judgment, yes, writ petition is maintainable. Thereafter, Union of India went up to the Honorable Division Bench, and Honorable Division Bench has also upheld my lord's view. Yes, writ petition is maintainable.
Now, can you turn to paragraph 16? Considering all other judgments.
May I leave my?
Yes.
May I leave?
Yes,
Yes, 16.
The decision-making process, my lord, one of the grounds, my lord, I am not on that. The proposition of law has been endorsed. My lord, will from the middle portion, my lord will find paragraph 16, middle portion. The proposition of law has been endorsed by the Constitution, endorsed by the Honorable Supreme Court, the authorities of ABL International, Brother of Honorable Patil and SUVRA. The placing reliance of the such and such. The Honorable Supreme Court in Uttar Pradesh Power Transmission has observed the High Court may entertain a writ petition notwithstanding the admitted alternative remedy, where the writ petition seeks enforcement of a fundamental rights, where there is a failure of principle of natural justice, where the impugned order or proceedings are wholly without jurisdiction and the virus of the act challenge. My lord, can you consider whether the act of the respondent being the eminent domain is permissible or not? Because the two things, my lord, the state can do without any permission. One is the law enforcing agency, and in other is, my lord, the taking the land. This is the two things with the eminent domain, the power vested with the state. Now, my lord, can you consider the next, my lord, your lordship find judgment which I have handed, that is Union of India versus M.K. Basu, because it is the Union of India who have challenged. That's why I bring both the judgments. Next, division bench judgment, Justice Banerjee and sitting with Justice Sinarai. Division bench, may I hand it over?
I will just check.
আচ্ছা না আমি ইয়েটা
সিঙ্গেল বেঞ্চটা ফার্স্টে দেখা
হ্যাঁ এবার ডিভিশন বেঞ্চটা আজকে নাকি ডাক্তার বাবা এখানে I have a copy, my lord.
No, I don't think you prefer.
নোটে দিয়ে দাও
না আমার মনে হয় একদিকে আমার তো আবার একটু ইয়ে আছে একদিকে প্রিন্ট
No, this judgment is not, I will not find it.
That is MAT number 1200 of 2022. My lord, I'll hand over to the entire thing as considered, and ultimately it was held, my lord. I'm drawing lots. Mm. 45, 46, and 47.
Please give me a copy of the judgment.
Yeah, I'll hand over to your lordship, my lord, because this portion, forgive me, my lord, is for probably I have handed over.
I do not find it here.
There is no, এটা আমার নিয়ম কি করবো পেজ নষ্ট করে কি লাভ এটা তো ফেলে দিতে হবে তাহলে আমাকে I'll get it. May I read out after that, my lord? I'll hand over 45. There's no absolute bar to read court entered in contractual disputes. My lord, so the word starts with the honorable division bench, where their court finds that though the dispute emanates from contract, the nature thereof is such a same can be adjudicated upon affidavits without holding a trial on evidence. Nothing stands in the way of the court to entertain a petition. Indeed, it will be within the power of the writ court even to record evidence if the court is of the opinion that a particular case is necessary to do so complete justice between the parties. The Honorable Supreme Court has time without numbers pronounced that the power of the High Court under 226 is plenary in nature. For the ends of justice, the order can be passed by the writ court. The power under 226 of the Constitution is very wide. It is for the writ court to decide whether or not shall exercise the jurisdiction in facts of the particular case. So long as the decision of the writ court to exercise not or not to exercise jurisdiction in the particular factual matrix is not arbitrary or unreasonable or perverse, the same would not call for any interference. So, my lords, what is following? All these judgments which I have shown, that was also been considered. My lord, forgive me, I always get it photocopy for you, my lord. This is one-sided printed copy, my lord.
You referred to paragraphs?
45, 56, 57.
45, 46, and 47. Here I am, the executive decision taken by the state. I want to enforce the decision. It is not that I want to cancel it. It is their decision. They have directed. But that's and ওটা কি এখন দরকার আছে
জয়ন্তীপালটা দিয়ে দাও
জয়ন্তীপাল জাজমেন্টটা ইয়ে করেছিস
না জেরক্স ওইটাতে রিলায়েড
আছে জয়ন্তীপাল তো রিলায়েড আপন তাহলে আবার আলাদা করে কি দেওয়া Grateful to lordship. At last, my lord, I am able to complete this matter.
Yes, finally.
In absence of Mr. General.
Let's conclude this judgment result.
না 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 আমি জানি না জয়ন্তীপাল জয়ন্তীপাল রিলায়েড আপন আগে এটা এম কে বাসু তো রিলায়েড আপন Grateful to your lordship, my lord.
Next.
Yes.
Item number 22. Time for the petitioner. Last occasion, your lordship directed, my lord, the state responded to submit a report because, my lord, Mr. Chondicharundi, my lord.
Where is Mr. Dev?
My lord, kindly see the last order, my lord, because, my lord, initially, this is the third time before appearing before the court, my lord. My lord, lastly, they have stated the land was not acquired. Initially, all documents shows land were acquired, your lordship directed.
Recorded also.
Yes.
But where is Mr. Day? Come back some other day because he is supposed to file a report. Please inform me. None appears for the state respondents. Paragraph, let the matter appear under the same heading on 6th September. Please inform me.
Your lordship direct them to file a submitted report, my lord, so I communicate the order, my lord.
Paragraph, report in the form of affidavit be submitted on the adjourned date upon service of advance copy to the petition.
Yes, ma'am. I shall communicate.
Item number 23.
Your lordship. Filing a supplementary. I am not opposing the adjournment. So, but I am for Union of India. Copy I am serving. There is a
Copy of supplementary.
supplementary. Your lordship was on the earlier directed to file supplementary with me. This is a supplementary. I am serving the.
Your lordship, I'm appearing for the railway authority.
Yes.
Well, I am for respondent number 1.
One.
Yes, Union of India.
ECL আছে
CLS, metro is the main-
ECL আছে
ECL?
PCL appeal.
হ্যাঁ ECL আছে
তোমাকে back to
হ্যাঁ।
পুরো ভালো। Is the copy. I have handed over copy to my landlord.
No railway in this matter.
Union of India.
Huh?
where-
না না
No railway.
ECL
Why not here, my lord? Union of
Union
India.
of India.
Hey.
A copy of the writ petition may be also served.
You are appearing for the Union of.
Union of India.
And the council says she is appearing.
Respondent number 1.
Yes.
You were also there.
You are for the ECL.
Your lordship, I'm the
ECL
junior of the advocate on record for the ECL authorities, your lordship.
Yes, you're ready today?
Your lordship, I'm seeking an adjournment because the advocate on record is on legs on another.
It's my fault also, my lord. I could not solve the supplementary. It's my fault.
Supplementary affidavit filed on behalf of the petitioner is taken on record. Paragraph. Care of the ECL, the matter is adjourned. Paragraph, let the matter appear under the same heading on 12th September.
Respondent number 1.
Item number 24. My lord, may please your lordship. My lord, may I just indicate, my lord, may I just indicate? My lord, I will not oppose, my lord, but just, may I just indicate so that he can take instruction on the next date and come back before your lordship. My lord, our section, my lord,
The position to take instructions also. Are you?
my lord, he can. My lord, I will communicate. My lord, may I just indicate what the matter is all about? My lord, section 5 eviction proceedings, section 5 proceedings initiated, the estate officer found on the submission of Port Trust Authority that though a sublessee, I am in authorized possession. My possession is not unauthorized. But however, grants a decree for my eviction as well. I will not go into all that. I prefer an appeal. There is a stay from the Howrah court. In the meantime, they come up with a tender. I am covered by your lordship's judgment. I say that I should have the right of first refusal. I have written 5 representations since 2014. There has been a complete inaction on their part. My lord, I can hand up a list of dates, my lord, if your lordship so desires. I can just hand up a list of dates. My lord, may I just hand up a list of. Oh, I'm sorry. Mr. Kishore Datta was appearing in this matter, my lord. Produce a list
You're
of.
for the Port Trust.
Yes, my lord. Mr.
Mr. Somnath Bose was appearing.
So Kishore Datta was appearing, my lord, was leading Mr. Bose in the matter, my lord.
Yes, yes. Sometime in 2022. After that.
No. Even as on 2023, Mr. Datta was appearing, my lord. Your lordship, it would be evident from the orders, my lord. My lord, kindly sees Mr. Datta was.
Private respondent also.
My lord, who was my original lesser? That's a respondent number 7.
He's also not appearing.
No, he's not.
Mr. Rudranath Bhattacharya.
Rudraman Bhattacharya, I'm, yeah.
It has gone down as Rudranath, it is Rudraman.
It's recorded as respondent.
It is wrongly gone down as a respondent. I was for the petitioner. Mr. Munshi is appearing with me.
Ms. Shushmita Chakraborty and Joyce.
They are the advocate, the erstwhile advocate.
They are the erstwhile advocate on records,
For
ma'am.
the petitioner.
For the petitioner, yes.
Oh, so everyone, give the proper names, please. Today.
My lord, I will indicate Miss Paj, I will ask Miss Paja Maulik, my lord, for petitioner. For petitioner, yes.
On prayer of. Respondent numbers 1 to 5. Comma, the matter is adjourned. Paragraph, let the matter appear under the same heading on 13th September.
Lord, may it retain its position, my lord.
And the private respondent will not have much of a role to play in this.
No, my lord. They have nothing to say, my lord. My possession was,
That's what he
yes.
served.
Yes. He was appearing also, my lord. I believe.
Essential
No,
service.
he wasn't appearing, but we have the
We have
affidavit of
the affidavit of service. He was appearing, my lord. May I just hand up the affidavit of service, my lord, in this connection, my lord. He was appearing.
Yes.
He was served. He was served.
I'm not sure that it makes sense. Sorry. Please come back on.
My lord, great.
Next.
Item number 25.
My lord, I am appearing for the petitioner. My lord, on the last occasion, your lordship was pleased to allow me to file a second affidavit of service as because original one was lost on the basis of the duplicate copies. And
Have you served the private respondent?
yes, my lord. The last one. All of them have received service.
Yes. Yes.
The Malad petitioner was granted a mining lease in the year 2012. He started without dispute. Sometimes in March 2015, there was another lease in the name of the wife of the petitioner. The second writ petition, next petition. In the meantime, the irrigation department allowed the private respondent on the basis of a short-term query permit. He entered into in between the petitioner and his wife's mining lease area and has constructed a road on the bank of the river. And therefore, he extracted sand from not allowed to him to take extraction. The petitioner went on complaining the department. Time and again, the petitioner made complaint. See, its complaint starts from page 24 to 26, 20, 27. Some representations have been annexed, 24 to 27. When the department was not doing anything, he filed a writ petition in 2015. At page 24, the order was passed.
Page 24 is your representation.
The order passed by in the writ petition at the relevant point of time. Page 28, annexure P4.
Yes.
In this writ petition, the Honorable Court was pleased to direct the authorities to demarcate the lands for the petitioner, for the short-time mining lease query permit holder, and the petitioner's wife. But the respondents, in the name of inspection, penalized the petitioner They made an inspection by after serving notice. My lord, kindly come to page 33. On the day of inspection, the private respondent agreed. Kindly come to page 33. The private respondent agreed that bottom one, top one is mine and bottom one is the private. মাননীয় মহাশয়, আমি শ্রী তারক কুমার জানা আজ 28/5/15 এডিএম এলআর এসআরও সাহেবের সম্মুখে টিএ সাহেব বিএলআরও সাহেব এবং আরও সাহেবের সম্মুখে 67 ফুটের মধ্যে যে রাস্তা ছিল তাহা আমি আজ হইতে তুলিয়া লইব এবং ভবিষ্যতে করিব না, করিলে আমার বিরুদ্ধে আইনানুগ ব্যবস্থা লইতে কোনো আপত্তি থাকিবে না। He made the construction, he extracted the sand, but the allegation was thrown on me only to suppress the throw veil on the over the inaction of the private respondent. He has been allowed to be excused and I have been penalized for an amount of rupees 11 lakhs of rupees. 11 lakh 6,000. Kindly turn to page 34, annexure P6. On the basis of inspection. But I did not do it. It has been admitted by the private respondent. 11 lakh 6,000. Challenging that order.
Admitted construction.
Yes, yes.
Not unauthorized.
He was, that 67 feet road, which blame has been thrown on me.
No, there is
Yes.
no blame of road on you. The blame, it's different. The allegation is
That
unauthorized.
time I made the complaint that he is extracting sand illegally. So the inspection was held on the basis of direction of this honorable court.
Admission of the private respondent is with regard to construction of a road.
Yes.
Construction of sand.
In the name of constructing the road, he was extracting sand.
That is not recorded here. Anyway, yes, what is your claim?
However, I did not extract any illegal, make any illegal extraction. But I have been penalized on the basis of joint inspection. Now I will come some, at page 32, the measurement was taken and I was blamed. At page 32.
Yes.
Thereby, the penalty was imposed upon me on 29th May 2015 at page 34. Then the department went on issuing me notice for implementation of the penal order. So, my lord, I again filed a writ petition before this honorable court. That time, the honorable court held that the writ petition is not maintainable. My last part of the order kindly passed by this honorable court, which is at page 43.
Page 40.
Page 43. WP number 20337W of 2015 is not entertained on the grounds indicated above, and the petitioner is left free to peruse the remedy of appeal available to the petitioner in accordance with law. Then the petitioner preferred an appeal before the district secretary, secretary of the department. As per the then rule, 2002 rule, he preferred this appeal. The appeal remained pending. The petitioner then filed a second writ petition, which is the order is at page, starts at page 44. This is the third writ petition at page 34. The authorities was directed to dispose of the appeal as early as possible, which ordering portion is at page 45.
Yes.
Then the authority issued the notice for hearing the appeal at page 46. Petitioner appeared in the appeal. Then authorities passed the order, which is at page 47 and 48, upholding the penalty order against the petitioner.
Yes.
The petitioner again filed a writ petition. That time, the rule 2016 came into force. This honorable court held that no, 2002 rule has been overruled and 2016 rule has come into effect. So appellate order was set aside. And the petitioner was granted liberty to file a fresh appeal before the district commissioner, Paschim Medinipur. Accordingly, the petitioner filed the appeal before the district commissioner, Paschim Medinipur. divisional commissioner. District commissioner, divisional commissioner. But that appeal was kept pending. Again in 2018, again in 2018, the petitioner filed an appeal, writ petition, which started at page 56. So this honorable court directed the authority to dispose of the appeal. The order was at length observing all the points, those came into pass in the last 3 years. Ultimately, the district commissioner, the divisional commissioner was directed to dispose of the appeal. Now, I will kindly come to the appellate order at page 60, annexure P10.
Yes.
The case is taken up today for order. Appellant is present, filed Hajira. Official respondent ADM LRO, DLRO, Paschim Mendipur is represented. I have gone through the appeal petition along with annexure. I have also heard the appellant and respondent. I have gone through the ordering portion is, my lord, at page 61. Paragraph number 3. Peruse the notice from the middle. Peruse the notice of joint inspection dated 18/5/2015, served by the ADM and DLRO Paschim Mendipur upon the revenue officer, Canal Revenue Division, Paschim Mendipur, in pursuance of the order dated 26 March 2015 of the Honorable Calcutta High Court in WP number 5473W of 2015.
A fresh inspection was done.
That 2015 order. That was the main order. Also peruse the measurement sheet dated 28 May 2015, signed by the BLLRO, Debra, SRO and TA, Revenue Inspector and Administration. It is seen that the said measurement sheet dated 28/5/2015 does not bear the signature of the respondent number 4 and 7. Nor does it bear the signature of the petitioner Sushanta Sasmal or respondent number 14, Taraknath Jana. Thus, it is clear that the concerned parties were not involved in the joint inspection as directed by the Honorable High Court, Calcutta in this case. Hence, there is apparently an inherent lacuna in the process. I therefore direct the ADM DLLRO Paschim Mendipur to carry out a joint inspection afresh. That means that joint inspection goes in strict compliance and accordance with the order passed dated 26 March 2015 of the Honorable High Court, Calcutta in such and such. Thereafter, decide the matter in accordance with law. After a fresh hearing of the petitioner and all interest parties by recording proper reasons within 4 weeks from date of communication of this order. Again, the department remains silent. Then, 5th round of litigation. Annexure P11 at page 63. Here, this Honorable Court kindly directed such conduct, the last portion I am reading at page 64, such conduct of the respondent DLRO West Midnapur respondent 2 to positively comply with the direction of 28 May 2019 passed by the commissioner respondent positively within 2 weeks from the date of communication of this order. Again, directed the DLRO to decide the matter in full and in accordance with the order passed by this Honorable Court as well as divisional commissioners. Then the joint inspection notice was served at page 62, 66. The copies was served upon all the parties. Then the Hajira and the sketch map drawing. Nothing was reported against the petitioner in the final report or the minutes of joint inspection. Only the demarcation of the land was held. No allegation of illegal extraction came. So, if the joint inspection report on the basis of which the penalty order was passed if the joint inspection goes, the penalty order also goes. So penalty order is not remaining. Then demarcation on the basis of direction of this honorable court and order passed by the commissioner in 2022, 7 years lapsed. Then this order of joint inspection was passed and ultimately they demarcated the land. Finally, after demarcation of the last question of leasehold areas, they are to having been signed positively within 21 2 seconds to the demarcation was passed and such minutes of hearing was signed by the authorities. Last portion I am reading, my lord. Attendance is submitted by the all concerned. Hearing starts at 12 noon. Hard at length. The record of joint inspection conducted, reference examined, asked questions by the court to all concerned, if any, it is expressed with voice of satisfaction. The event of demarcation in compliance of the order aforesaid is successfully conducted with unanimous admittance by the Sushanto Sasmal and Taraknath Jana. No question of penalty was there. So after the demarcation was made, I ought to have been allowed to continue the release deed. Thereafter, the department remained silent. Then I made a representation. You allow me to start the work. There was a 6th round of litigation. This honorable court passed order. Then I went on praying the department that kindly allow me to continue my lease deed by issuing me permit. But the department remained silent. But now, my lord, after filing this writ petition, the department woke up with the same penalty notice which was passed in 2015. I could not annex that penalty notice in this writ petition. I would like to pray your honor, lordship, to file a supplementary affidavit to bring that penalty order, so that your lordship can adjudicate the matter concerned. I am entitled to continue my lease without any penalty.
Yeah.
To allow me to continue the lease, I am coming to my lease. A writ in the calling upon the state respondents for asking them to show cause as to why this honorable court will not kindly quash the orders demanding penalty for rupees issued on 29/5/2015 and 11/12/2005, and so cause as to why they will not allow the petitioner to continue the lease for the lost period of 3 years, 10 months by issuing carrying orders after its resuming as lost from February 2005 till the date until the completion of lease period of 5 years.
This demand is no longer there. It doesn't exist now.
My lord?
Because after this demand, the fresh joint inspection was held.
No, this is the final time I filed the writ petition. As because they were not allowing me to continue the lease.
So you have assailed the demand notice of 2015. Prayer A. Yes.
Because the demand notice cannot remain.
This is no longer existing.
Yes, 9. It is not there. Even then, they are claiming this amount from me.
No, you say that they've issued a fresh demand notice.
No, that notice did not come. I was asked to, I was called in the office and I was asked to pay this amount. That is why I challenge this. But demand notice have been thereafter issued.
After this demand notice, the inspections were held. First an inspection.
Inspection made
that was turned down. A second inspection
Yes.
was directed to be held.
There was no question of penalty.
After the demand notice.
Yes.
Yes.
Yes. Demand notice is not there. Ultimately, demand notice is not there as per law, impliedly. But now, after filing of this petition, they have again issued a demand notice. That is why I am praying for filing a supplementary.
These prayers are redundant.
This prayer, I praying for allowing me to continue the release deed.
Where is that prayer?
Prayer is bottom of that prayer.
Because prayer A is redundant.
Then, my lord, after 11 to 22, 25,
For renewing.
and show cause as to why they will not allow the petitioner to continue the lease for the lost period of 3 years, 10 months. By issuing carrying orders after this resuming at the lost from 2015 till the date until the completion of 5 years lease.
You filed a representation to that effect.
Yes,
Where is it?
my lord, there are 2 representations I have filed. Kindly come to
For
page,
extension of the.
page 83, annexure page 13. Then
83.
85,
The 83 is P13, yes.
85, 86, then again at page 87. Then I served a notice from a page 88, discussing all the facts, directing the, claiming the authority to issue the contract permit, carrying orders.
It is a demand of justice.
Yes, I went on breaking demand,
So
but
this
they
has-
did not whisper.
This has not been considered.
No, nothing. 7 except issuing an order of penalty in terms of the order of penalty in 2015. That order I want to implead in this petition.
Let
It-
him come back with a supplementary affidavit in this case.
As because the prayer for washing or setting aside the impute. Teacher is challenging the ordinary.
No, that has gone. Actually, after the district commission,
The demand notice is not there at all now. So that prayer is redundant. The second prayer for extension of the lease,
My suggestion is this, my lord, if your lordship, my lord, accept, my lord, his representation be considered by them for renewal or.
then the penal order will remain.
Then he has not applied for renewal. He has stated by the prayer before the authority for extension or granting the period.
lost,
Lost.
My lord, confusing, my lord. My learned friend is confusing. Until and unless the 5 years is completed, renewal cannot come into question. I have stated, I have given all the evidences before the court. I have given all the evidences before the court that I was stopped from running the list since 2015. Without demarcation, I could not continue.
the representation, you have asked for compensation of the lost period.
Yes.
You want
Then only renewal question will come.
extension for the lost period.
Yes.
So let your representation be considered by the authority.
If your lordship kindly allow me to continue directing the authority to continue the.
The court cannot direct the authority to allow you to continue. The court can only direct consideration of the representation. This is a judicial review, sir.
But thereafter a penalty notice has been issued. That's why I want to challenge that in the supplementary affidavit. Otherwise, again, the penalty will remain. I will come before this court.
Let's come back with the penalty notice because it's during pendency of the writ petition. Affidavit of service.
খালি ভূত বানাতে চেষ্টা করে
The
স্বভাবটা গেল না স্বভাবটা এখনো গেল না
demand of penalty issued by the state respondents upon the petitioner on 29th May 2015.
Yes,
There are two demands.
one demand
You
notice.
have stated 2 dates.
No, the second notice was issued for implementing the demand.
But it is 29th May 2015.
Yes.
Is assailed in the writ petition. Stop. It is not in dispute that the said notice does not exist at present. Stop. Paragraph, it is submitted on behalf of the petitioner that during pendency of the writ petition, a further demand notice has been issued upon the petitioner demanding petitioner on the basis of the earlier notice. Stop Learned Counsel seeks to use a supplementary affidavit in this regard. Paragraph, let the matter appear under the same heading on 12th September. Please serve an advance copy.
But the next read petition is for the wife, same, analogous. And my life, I am filing the affidavit of such.
Item number 26.
So
I
let
am
it just be adjourned till
same,
12.
same.
For the state respondent.
Let it be adjourned till 12 because he wants.
Similar issue, the penalty he has not paid lot and his primordial prayer in the reputation is that unless and until your lordship can see that the primordial prayer is that he wants the cosment of the penalty. More than 20 lakhs of rupees, he is not paying them.
Here is the penalty amount is 22 lakhs.
22 lakhs, he is not paying.
Penalty order has gone.
But after this penalty order, inspections have taken place. Lot of water has flown through the Ganges.
But my instruction is that he has to make the penalty, my lord. My
Have you
instruction
made
is,
another prayer for penalty?
no, in this read petition, he has made the prayer, your lordship, can you see that?
Have you received a second prayer in this petition
Your
also?
page 16, my lord, the prayer A.
You want to use a supplementary affidavit here
আর কি বলছে
also?
শুনুন।
I want to file a supplementary here also.
During
The same thing, same happened. Yes.
Have received another notice.
Same thing, same,
My lord,
This
same date of
penalty notice-
penalties.
আরে শুনতে দিন।
This penalty notice was issued. After that, it was found that the joint inquiry was not in accordance with law. So that was cancelled. A fresh joint inquiry was held all after the notice. So this notice has become redundant. It's
My lord,
impliedly set aside. It's not there at all now.
I have seen that,
dispute.
I have seen,
Yes? So how are you claiming this amount?
No, but he has made the prayer here, the prayer,
Prayer.
primordial prayer, your lordship kindly look into that. A read in the nature of
I see
maneuvers
the
for
prayer.
calling upon the
I
state
have
respect.
seen the prayer. But this notice is no longer there.
This
Learned
notice,
Counsel
notice of
says-
2015.
That is not there at all because after that it has been taken up on several occasions by the authority. Learned Counsel says that during pendency of the writ petition, another notice has been issued. So for claiming the same amount.
My lord,
So he wants to come back with a supplementary affidavit.
what?
Yes.
আর একটা নোটিশ দিয়েছে তোমার?
Date of service বলে আগে same.
Penal notice দিচ্ছে আবার।
Penal
The
notice,
same date,
but your lordship is fixing on September,
12.
12 September.
12 September. My lord,
Deeply.
Yes.
but this is a separate order, your lordship.
Separate order, yes.
My lord.
Item number 27.
27, I'm for the petitioner, your lordship, I'm praying for adjournment.
Why?
My senior is out of town. Kindly fix it in September at any date.
Why don't you make your submission? You're not ready?
No.
আপনার নামটাই দেবেন।
Have you served the private respondents?
Yes, your lordship.
আপনার নামটা কি ম্যাডাম?
Number 5.
আপনার নামটা দিতে বলেছি।
Let it be adjourned. They have filed a representation.
Page 14.
Page 42. Page
14 wala, P2. Illegal removal of soil.
We are out of session. On the read.
But this is private land.
Private land.
Let her come back. Those may not be maintainable.
Yes.
None appears for the private respondents despite service. Paragraph on, please be ready on the next occasion. On prayer of the petitioner, the matter is adjourned. Paragraph that the matter appear under the same heading on 6th September. Good.
28.
Statement.
But I appear for WB Hitco. On the last occasion, my lord's pleasure was that we should file a report in the form of an affidavit. But we have done so. My lord, may I serve a copy on my learned friend? No. Hitco. Stated কিছু যাই না stated হয়তো হবে না জানি
দেখতে হবে অনেক কথা আছে
আপনি petitioner
Now, this short prayer in the case, my lord.
The HITCO says that the demarcation has been done
yes
and the acquired portion has been ascertained.
yes
Lord, the things for a moment. Lord, one plot, about 11 persons possessing the same plot is 139. Lord, the portion of the land has been acquired by the for the purpose of requiring body, HITCO, and for the rest portion was the royalty land. My respectful submission, the HITCO taking the advantages of the acquisition position, my position has been encroached without demarcation. My kindly say appreciate, Lord, the annex the document annexer P6. Some persons come before this court, my lord. Similar order has been passed. Some persons in respect of the same plot, but in case of my case has not been demarcated. This has been prayer only for similar prayer should be done. Last page. Page annexer P6, your is passed an order, and also the page 68. Page 68, your lordship passed an order. And another order has been annexed. Next up, P6, page 64, operating portion 64. None. My respectful submission with in a same plot, more than 11 persons are possessing the rest portion of the acquired position. And my representation and annex of P7, page 71. কি দিয়েছে ওটা কি দিয়েছে ঝর্ণা তো আমার নয় ঝর্ণা তো অন্য কিছু আরে প্লট একটা প্লটে অনেকে মেম্বার আছে
Say that the unacquired portion has also been encroached upon.
Yes, my lord.
The unacquired portion has been utilized by the HITCO. That is
Yes.
your case.
That is the only grievance and only for the particular purpose for inquiry into the L in presence of the parties. But for the purpose of demarcation.
This
And
plot,
this is my lord, the annexer, representation annexer P7, page 71.
your lordship had the occasion to consider the claim for demarcation in respect of this plot in a different writ petition. Kindly sees my lord's order at page 22 of the report. 22 of the report file just.
আমি annex করেছি তো, that is ওই কেসে।
If your lordship kindly sees page 22.
Yes.
May I please it, the primary grievance of the petitioners in the writ petition.
Oh, yeah.
Primary grievance of the petitioners in the writ petition is that the state respondents are encroaching upon the unacquired portion. The next paragraph, it is submitted on behalf of the state respondents that the entire plot number 146 and portions of plot numbers such and such in Moja such and such has been acquired in LA case number such and such. The acquired portions have been demarcated by the state respondents in the presence of the petitioners. In view of the above, nothing further remains to be adjudicated in the present.
No, that is their.
And thereafter,
another writ petitioner, not my case.
But the land is the same, the plot is.
Plot is same. In one plot, big plot, one plot, some portion has been acquired, there is no objection to that. By acquiring portion of this, only written portion, my lord, if about 11% are possessing. So my portion has not been.
Has been demarcated.
They have stated,
Yes.
but so my contention is requiring body already, my lord, the encroach my portion. And that is, my lord, the case here. So my responsible submission in my case should be inquired into this matter, but for the purpose of demarcation. Only they have stated the acquired position demarcated. When the question arises, if it is so, why my land has been, my lord, encroached?
but perhaps, my lord, subject to correction, my learned senior friend has not been properly instructed. Your lordship will kindly see page 19 of the report once. But here we have filed a report in compliance with your lordship's directions in the other writ petition. This is a detailed report giving the plot number, the total area, the total acquired area and the respective LA case numbers. Then kindly sees this report.
That I am stated in the writ petition, what portion has been already acquired, what portion acquisition is affected. I'm already stated. That is not this.
And the entire plot has been demarcated and the plan has been given, which is at page 21. This plan has been annexed, showing which is the demarcated portion, which is the acquisition line and the existing possession line.
Why the land and pen, my lord, the afraiding, my lord, the things for a moment, when my subject matters, my land has been encroached. That is the question arises. That's why my application is before the lordship. Annexer P7, Annexer P7, page 17. Why they're afraid so? I am not challenging the acquiring portion.
You are asking for consideration of your representation.
Yes. For holding inquiry.
But let my learned senior friend consider the report which we have filed. If he is not satisfied, he can come back and.
I am not
indicate that.
disputing about the acquiring
The
portion.
entire portion has
I
been
am not
demarcated
disputing.
already. In
That is
respect of this
true.
plot.
I am not saying.
Despite such demarcation, you have encroached upon unacquired portions.
Yes.
That is clear.
This is at as late as in April 2023. Your lordship, on being satisfied with the report, the petitioner is being satisfied with the report, your lordship disposed of the writ petition. There is no challenge to that.
It's a different petitioner.
I understand, but that's a demarcation of the same plot. That has been done already.
No dispute with regard to the demarcation of the acquired part.
I am not.
This petitioner comes up and says that you have encroached into unacquired portions.
Yes.
But that is, his writ petition predates the order. His writ petition possibly, subject to correction. His writ petition has been filed prior to this development.
About
This has been
11%.
filed on 20th of September 2022. This report which has been prepared is done in sometime in April. Your lordship had considered this year.
He has no quarrel with the report.
I am not given opportunity. I have not.
Report is perfectly all right. He says despite such report of demarcation, you have encroached upon other parts also. Beyond this demarcated plot.
Let him say this on oath, challenging the report,
That is his case.
indicating that
That
he has
is
not.
his case.
But he has his case is.
Prayer B, my lord, they kindly appreciate what I am prayer.
Well, because my instruction is that whatever was there in this plot has been demarcated. The acquired, unacquired portion, everything has been demarcated.
Cannot be, the acquired portion has been demarcated.
Has been demarcated. So the unacquired remains outside the demarcation. So the petitioner is sufficiently covered under that.
Says despite that, you have entered
in-
into his
But
portion.
in the writ petition, the cause of action is something prior to this action of demarcation.
That
So he cannot
demarcation
now
has been
say,
held in absence of the petitioner hearing. Petitioner has not given opportunity.
but his cause of action in the writ petition is that there was no demarcation. After that, in some other writ petition, demarcation has been done. So his writ petition cause of action, possibly subject to correction, is no longer subsisting.
Prayer B may have become redundant. That is demarcation,
Yes.
but prayer A says encroachment.
Yes. So, my lord, what my submission is that this prayer B has been carried out in a different writ petition in respect of the same plot.
It's redundant. That's over. That part is over.
Yes,
What
that
was
is,
prayer A?
yes. So prayer, this entire prayer of the writ petition is of September 2022, when there was no demarcation done. Your lordship directed us to carry out a demarcation in respect of this plot, which the petitioner is also claiming now. So that demarcation has already been done. A plan has been filed
That was
to
supposed
show which is the demarcated portion.
That was supposed to be done in presence of both the parties.
Yes,
Mr.
that was done.
Petitioner Was not a party there.
Not a
So
party there.
His presence, he was not there. He was not present when the demarcation was done.
Yes.
But the petitioner probably has no quarrel with the demarcation. He says demarcation was done, despite which you have entered into portions beyond the demarcated lines.
Yes.
But that means they want to put a demarcation instead of their unaccurate portion of it. That means government cannot
No,
demarcate.
no. You cannot demarcate unacquired portion, but you cannot get into unacquired portion also.
Acquired portion has already been demarcated. It appears to the opposite.
And that's true. They are after
Unacquired-
encroached.
The acquired portion is demarcated. No dispute with regard to that. He says you have crossed the demarcation line.
If cross the demarcation line, that means what they take the private land manner.
Yes.
Government has no authority to demarcate, but government takes the
But
private.
in paragraph 9, I have indicated, kindly sees the report paragraph 9 at page 4 of the report.
You say that you have not encroached upon.
Yes. So let him, if he still tries to, my lord, argue that there has been an encroachment, let him take an exception if he wants. Otherwise, my lord, it's a clear instructions on oath that this has been demarcated, no encroachment. So in case he is
My lord,
joining issues,
My lord, my respectful submission, why my learned friend afraid of this? My simple prayer to inquire into the matter, since not only the petitioner, about 11 persons are possessing the land in the same plot. That is,
You're not concerned with the 11 persons or the 10 other persons. You're concerned with only your portion of the land.
that is my concern is a simple prayer. Why this afraid of?
Your representation is for demarcation of the acquired land.
Yes. Paragraph
that has been done.
71.
That has been.
That
done.
has been done.
Demarcation of what?
Acquired.
Demarcation of acquired land. My respectful submission, if it is done, then why the encroachment my property is? That is the question they should have said by holding the inquiry that it is the demarcated portion and it is your land or others' land.
The report says that demarcated. portion,
Demarcated report says, my lord, demarcated only the acquired portion.
That is only used by the HITCO. The HITCO has not encroached upon any land beyond the demarcated portion. That is the report. So what further lies?
That is report in favor of the other petitioner, not in case of the.
In this writ petition, today's report.
That's-
Today's report.
Today's report, my lord,
Right.
I've just now served him a copy with this. one.
just now I have not seen. Not a problem. My lord, over the unacquired portion of the then petitioner, not in case of the petitioner.
This petition.
I have,
sir,
only paragraph 9, the plot number, I have seen the plot number 139 is the big plot. Has been duly surveyed and established has not been encroachment over the unacquired portion of the land.
And what is
That
your thought?
my consider, my lord, in spite of that, my property has been encroached. If it is
Plot number is 139?
139, 139 is a big plot, not the one, my petitioner only. There is about 11 persons, my lord, possessing the land.
You have said that, sir.
So, I mean, so my lord, I kindly appreciate. Huh?
The HITCO says that the remaining portion has not been encroached upon. Do you want to use an exception to this?
Of course, it is the exception is required to be exception since,
Said that earlier, sir, after so much of.
no, my lord, the migration report just now has been served upon me, just served upon me.
Yes, I'll give you an opportunity.
Yes, then your lordship,
Clearly says that there is no encroachment.
they clearly says no encroachment in case of the report was filed, submitted on the other petitioner.
Oh, in case of in your
In-
case.
In case of they have report, when the inquiry has been done, when the inquiry has been done,
Today's report.
today's report on the when the inquiry.
Dependency of your writ petition. Your writ petition predates the.
Then lordships, I filed the exception. Then I filed the exception.
Report in the form of affidavit submitted on behalf of respondent numbers 3 and 4. And affidavit of service filed by the petitioners are taken on record. Paragraph, learned counsel for the petitioners seeks to use an exception to the report. Paragraph, that the-
কোনো ঘরে ধরছে না সব জায়গায় হবে হবে করে হচ্ছে
8 September.
8.
My lord, before my lord license, my lord,
May I most humbly pray, my lord?
item 50, my lord, is for withdrawal, my lord. We've settled the matter between, my lord, item 50, kindly allow me to withdraw.
No, I cannot jump right in.
Lord, may I most humbly, my lord, the next matter, my lord, kindly takes it up on Monday if it doesn't, my lord, inconvenience, my lord.
Sir, কবে রেখেছো?
8 September.
29.
Next matter. I do not know who is there for the respondents. It will appear on Monday. Come back, please.
Grateful, dear.
My lord, item 50, I've served the respondent. The respondent is here.
I am 28 now, sir.
103. It's quite. Brief কোথায়? Brief কোথায়? Brief কোথায়? এটা দিয়ে ঠিক নেই করে।
Yes, call the list, please.
Item number 103. All I'm appearing in this matter, behalf of the petitioner. The church. Mr. Sen is appearing on behalf of the Alice contemners.
Yes.
Personal or direction, my lord, info.
Compliant, Mr. Day, Mr. Sen,
Not yet. No.
not yet.
But not yet, because I've got the instruction because my client was called and tomorrow. No, বলতে আমার বলেছি যে আমার মানডে ডেকেছে বলুন তো না না আমি তো বললাম যে আপনি বলুন
May I just, my lord, may I tell you, lordship, my lord, after this order was passed by a coordinate bench, my lord, on 16th of April 2020, my lord, in terms of the order, a decision was taken and it was also communicated. Now, what happened? After it, my lord, they realized that this decision was taken without giving an opportunity of hearing. So that is why it was in 2020. And the order was passed sometimes, my lord, at the end of 2019. So far I recollect. And in 2020, and the first part, this order was passed. Later, my lord, they realized that this order was passed without giving an opportunity of hearing. Thereafter, my lord knows, I do not want to repeat that COVID situation and other thing, which was not normal. Then, my lord, a contempt petition was filed. Now, my lord, I should be candid to that during pendency of the contempt, my lord, a notice was served upon the petitioner that to appear before the court, before the RTS secretary for the purpose of, this is, my lord, of 10th of August 2023. Very recently, my lord, yes, my lord, I admit it.
So hearing has not been done.
Yeah, yes, hearing done, and the, my lord, the petitioner's representative, possibly, my lord, his brother, my lord, also appeared on the day of hearing, and this is the order passed. Now, I shall, my lord, I pray, my lord, at least 1 week time and not more than that to, my lord, submit all these things by way of a, my lord, compliance, yes, my lord, affidavit. Now, if my learned friend's client, my lord, dissatisfied with the decision taken, either the reason or anything, my lord, he can always challenge the same. Yes,
I shall give the reply. Yes.
Course of action.
I shall give that. If that decision is not at all,
Please come back with
My
the affidavit of compliance. Definitely.
well, advance copy so that I can reply.
Learned counsel for the alleged contempt submits that the order under contempt has been complied with. Stop. Learned counsel seeks to submit affidavit of compliance on the adjourned date. Paragraph, let the matter appear at the same on 25th August, next Friday.
25th
August.
Yes, sufficient, my
Sufficient.
আপনি তো শিখেছেন।
না না আপনি আমার সিরিয়াস কি বই পড়েছেন
Yes.
Smile.
One 104.
Well, I am appearing for you. I am appearing.
Yes. Shana?
My lord, I can give the petitioner. This matter was heard by your lordship on the earlier occasion. And there was a matter deals with, madam, let's come.
Yes.
The petitioner before your lordship has purchased a bus from one Birendra Gupta. This bus was initially purchased by Joy Shah through a hire purchase agreement from Canara Bank. The Canara Bank, he has failed to pay the installments. He has declared an NPA. He himself executed on terms that termination of agreement has been cancelled. After Birendra Gupta, it has been transferred. The petitioner, present petitioner has taken the bus. Now, thereafter, some way or the other, the RTO has put the name of Joy Shah, that is the previous owner who has failed to the installment, in the present scenario. And now presently Joy Shah is flying the bus. The only issue is that, my lord comes to the petition number 1, annexure P1, where the RTO themselves has stated that they're sorry for an unintentional mistake that the vehicle is returned to Joy Shah, to the previous owner. That is just after the affidavit, page 15. And my lord, on the earlier occasions, my lord has directed to give an affidavit by the bank, which my lord, I have also received a copy.
My lord, may I be permitted to file the affidavit on behalf of the bank, my lord? My lord, all the documents I have categorically enclosed so that there is no difficulty.
Purpose notice served upon the, who is appearing for the private respondent?
But earlier occasions, someone appeared.
He appeared, my lord.
Joy Shah.
Joy Shah. Mr. B. Roy and Mr. Amit Haldar, they were appearing.
They were appearing, my lord.
They I do not find any.
No, ওরা হচ্ছে private officer, Joy Shah.
Yes, was notice issued upon the private respondent?
Yes, my lord, they appeared.
They appeared, my lord, on the
Confiscation of the vehicle. Where is the document?
My lord?
That was the specific query made in the earlier order.
Yes, my lord.
Where the notice was issued prior to confiscation.
Yes, that was. That was, my lord, that I have
The
gone
bank
through.
was supposed to take instruction.
Yes. My lord, kindly comes
There is the
for the
notice.
page that page 20 of the affidavit given by the bank. From that onwards. Most importantly, my lord, comes to page 23, it will be crystal clear.
Page 20 is addressed to one Virendra Pratap Gupta.
No, my lord, come to page 23. There is a signature of Joy Shah on form 35. To the registering authority PWD Kolkata, we hereby declare the agreement to purchase, lease, hypothecation entered between us has been terminated. We therefore request that the note endorsed in the certificate of registration of vehicle number this in respect of the said agreement between us stands cancelled. Signed by Joy Shah.
This doesn't demonstrate that a notice was issued upon Joy Shah.
No,
Prior to confiscation of the vehicle, because you say that the account was NPA.
it was
You could
NPA.
not repay the loans.
Not
But
repay the
this document is otherwise.
No, my lord, if my lord, what notice says, my lord, what motor vehicle tax is on the earlier occasions, but I've gone through it once. But if my lord kindly takes the difficulty to kindly comes to 51.5 once again, my lord.
When you take away the vehicle, you have to serve a notice, isn't it?
My lord, what happens, my lord, in surface C, my lord, once this gets an NPA, my lord, they issued a note that notice was issued to Joy Shah that you have been NPA. That I have, that they have done it.
Newspaper publication
My lord, kindly comes to page 22
of the report.
of the affidavit. But one by one, it will be done, my lord.
Page 15.
My lord, recall notice that is at page 15.
Recall notices at page 15.
It was given to Joy Shah.
Thereafter, newspaper publication. Page 17 and 18.
Thereafter, after the recall notice, option was given to him. Thereafter, there was a paper publication. After the paper publication,
Participated.
the auction was held and Virendra participated in the auction, and so on the process went on.
Sale certificate was issued.
Was issued.
And documents were handed over. Page 20. Second documents were handed over to Virendra.
You've asked for registration in your name. That
Yes,
is
my
your
lord.
prayer.
Yes, my lord. And presently the bus is flying by Mr. Joy Shah. That is the issue. Because the RTO has registered wrongfully to Joy Shah. Now Joy Shah became the registered owner.
Where is the RTO's document saying that they've done it wrongfully?
My lord, kindly comes to the in my application, it is at page 15, and in the affidavit, it's at page 24. My lord, may I read it out for your lordship, my lord?
Yes.
Whereas it would transfer first in the name of the bidder, then the bidder could sell it to any person. Therefore, to rectify the procedural latches, now the vehicle is returned in the name of Mr. Joy Shah, the previous owner. The office feels sorry for his unintentional mistake. That's it. Hope you'll understand the situation. Next auction shall be taken according to procedure.
Given to one Shiburam, my.
Shiburam might, I am the owner, present owner. I have taken it from Virendra Prasad. Pratap, sorry. my-
Next action will be taken according to procedure. Let us hear Mr. Debra. Yes.
My lord, there is some mistake on the part of my lord Bahon. Bahon portal says that is the Joy Shah. That is some mistake. If your lordship kindly direct the authority that after compliance with section 51(5), they can register the vehicle. So after compliance with the provisions of section 51(5).
My lord, 51(5) is the process is a cumbersome process. I'm telling. I'll read it for you.
Definitely, that has to be complied with.
No, there is a small word where the person whose name has been specified in the certificate of registration as the person with whom the registered owner has entered into the said agreement satisfies the registering authority that he had taken possession of the vehicle from the registered owner. That has been done. Owing to the default of the registered owner under the provision of the said agreement, and the registered owner refuses to deliver the certificate of registration or has absconded, such authority, my lord, here I will stop, may, after giving the registered owner an opportunity to make such representation as he may wish to make by sending to him a notice of a registered post acknowledgement due at his address entered into the certificate, and notwithstanding that the certificate of registration is not produced before it, cancel the certificate and issue a fresh certificate of registration in the name of the person with whom the registered owner has entered into the said agreement. It is may, well, it is not shall. The word is may.
So it's the discretion of the authority.
Yes.
He is using his discretion.
That is may, my lord. That is only thing.
Subject to compliance with 51(5).
My lord, my lord.
It will be transferred to my name, my lord. Well, kindly gives that observation to that effect. And my lord, presently the vehicle is being plying by Mr. Joy Shah. To that effect, my lord, kindly gives a.
That is, my lord, I can.
The vehicle was given to him by order of a court, I find.
Yes.
The 156(3) proceeding, a case was started.
Yes, the
Case
process
was started, yes.
but
yes.
I was not made a party. But I'll give the 156 clause 3 also.
On the basis of the court's order, he is flying. I do not.
No,
know.
no, not at all.
Yes, it's flying by virtue of a court's order.
My lord, kindly comes to my lord. My lord, this is the one. My lord, can I give it to my lord?
It was returned against the relevant order. Do you have it with you?
My lord, this is the 156 clause 3, where Joy Shah and senior branch manager and Sri Sushanta Mondal, representative of Calcutta Investigation Detective Department, is the part.
That criminal case was started.
Under 166 and 166A.
Vehicle was returned to Joy Shah by order of the court. That is recorded in the earlier order.
No, my lord, that is recorded, but that document is never shown. I have gone the order sheets, my lord.
My lord, he has to vacate the said order. Otherwise, there is a difficulty.
Oh, my lord, one thing, my lord, it
What
was.
authority will do?
My lord, there is kindly see, my lord, there is no order stating that you take the vehicle. Matter was started under section 166 and 166A, which is a disobeying of the public servant. It was a prayer also.
Have the orders of the
Yes,
Chief Judicial Magistrate?
yes, my lord, I do have.
The orders?
I do have. Okay, fine.
Because the private respondent submitted that it was returned by order of the court.
But I do have all the orders, but some other orders, this one is very legible. But another order I do have, which is.
No, I'm looking for the relevant order.
This order, one of the relevant order, I'll give it to your lordship.
This is just calling for a report. This is not. There must have
My
been an
lord,
order for
there
return
was-
of the vehicle.
My lord, I'll,
Otherwise, vehicle wouldn't have gone to your shop.
yes, my lord, but I do gather because as per the honor,
If the vehicle is registered in your name, how do you get back the vehicle?
my lord, but as per my instructions, there is no order from 156 clause 3 that they will get the vehicle. Subject to corrections, my lord, I'll get the order within a week. My lord, let me come back after a week, I'll get this order, but let me have a proper document to before your lord.
Clause 3 directs registration of a case. So in 156 clause 3, there cannot be an order for return of vehicle.
No,
A case is registered and there has been an order for return of vehicle. Please find out that.
no, my lord, that is not the case, my lord. Subject, my lord. 156 clause 3 was filed under section 156 and 166 of the Indian Penal Code, which states there's a deserving by the public servant. Maybe there was a deserving of public servant. And the petition itself states that there was no prayer to return of the vehicle or to take the vehicle. In fact, the orders in 156 clause 3, there cannot be an order to return the vehicle. It is only under section 457 CRPC.
So hearing the petition,
My lord.
then after the case was registered,
Yes, my
maybe
lord.
there was an application for return and that has been allowed.
My lord, I will find out that, but I'll find out, my lord, but I'll come back.
Allowing this restriction will not serve your purpose.
Not to serve the purpose, because once again, I'll go back to 156 clause 3.
Yes.
That's it, madam. Well, I'll come back after 2 weeks.
2 weeks.
2 weeks will be enough.
Come back with a supplementary affidavit in that.
I'll
case.
definitely
Get the order.
get order.
My lord,
Steps before the court.
may I say something? My lord, so far as the bank is concerned, I have filed the affidavit, which clearly
yes.
shows that recall notice was there. Thereafter, he became NPA. We seized the vehicle. The auction was held. Birendra Pratap was the highest bidder. We submitted all the documents and the handing over of the vehicle also was done to Birendra
And you
Pratap.
informed the same to the registrar.
RTO, the registry.
Have that.
So the bank's part is very much
Over.
clear, my lord. We have nothing else to do.
Come back on the next steps. And then appears for respondent number 4. Paragraph affidavit in opposition submitted on behalf of the third respondent is taken on record. Paragraph, heard learned counsels for the parties. Shall I record that you want to come back with a supplementary affidavit?
I'll come back with a supplementary affidavit.
Paragraph learned counsel for the petitioner seeks to use a supplementary affidavit annexing relevant documents.
Actually, sir.
Paragraph, let the matter appear under the same heading on 13th September. 13th, 1.
My lord, my lord.
Deeply obliged, my lord.
Grateful, your lordship.
Deeply obliged.
Item number 105.
I am appearing, my lord. I am appearing, my lord.
Yes, is the permit renewed?
My lord, I am for the petitioner. My lord,
The permit is still not renewed, your lordship, as the objection was invited for renewal of the permit, your lordship. Of some objections has been raised, and your lordship, it will be decided in the meeting on 28th, your lordship. Your lordship, I would like to point it out to your lordship.
28 of this month, my lord, there will be a meeting of State Jharkhand for renewal of my permit.
So will you come back
Let it be adjourned after 20.
Lordship.
STA Jharkhand that a meeting will be held by the authority on 28th
Lordship,
August,
I may be correct, it's 26/8.
on 26th August 2023 for consideration of renewal of the permit of the petitioner. Paragraph, in view of the above, comma, let the matter appear under the same heading on 6th September.
Lordship.
Item number 106. My lord,
I am appearing, my lord. I am only asking, my lord, some time to extend
My-
the extend the affidavit opposition, my lord, this is not prejudice because vehicle has been released upon payment of all the fees. Now, my lord, lordship decide whether is it correct or not. So let it be, my lord, affidavit opposition be filed.
Yes,
My lord, senior counsel in this matter is out of town.
he's
Kind,
asking for an adjournment, the petitioner.
Oh, then my lord,
kindly adjourn 1
2
week.
weeks to adjournment.
We are appearing for respondent number 5, manufacturer, Tata.
Learned counsel for the petitioner seeks accommodation. Paragraph, learned counsel for the state respondents. Seeks extension of time to file report, to submit report in the form of affidavit.
My lord.
The matter appear under the same heading on 8th September.
My lord.
8th
My,
September.
my lord.
Grateful.
8 separate.
Item number 107.
Well, I am appearing also.
Yes, petitioner. Mr. Mukesh.
I have filed my report, my lord. Lordship, kindly go through my report.
Where is your exception? You wanted to file an exception?
But I have already taken out the exception, my lord. I have served the copy in advance, my lord, this exception.
Mr.
I have
Dev,
served.
you received a copy of the exception?
Yes, I have served, my lord, wrong way.
No, I have not,
Perhaps-
right now, I have not in my hand.
He has
Anyway,
not come
lordship.
to where we have served, because he has not come to court, but he has not received it perhaps.
So lordship kindly
It is who is his clerk.
adjourn after 20th, lordship, any day, lordship kindly fixed it.
After 20th,
Yes, 28th.
please come back.
My lord, next, any day of the next week, your lordship, well, because vehicle is standing idle. Only thing is that, my lord,
Nothing can be done. Nothing can be done.
allegations.
Well,
even, my
decision was taken, lordship kindly, decision was taken 2016 for transfer of vehicle. Thereafter, they applied for renewal. Decision was taken for transfer of ownership 2016. Now he come with a vehicle, well, at BS3, yes, BS4, without BS4 vehicle. Now he has come to transfer the vehicle. That cannot be permissible. 2016 decision. Not heaven will fall. Mr. Mukherjee knows.
Why 2 exceptions?
One is from the private respondent, because my vehicle should be transferred to the petitioner.
Well, the facts, your lordship.
Even then, my lord, those name has not been transferred. Who has applied for renewal?
Exceptions submitted by the petitioner and the private respondent are taken on record. Paragraph. Copies are not served.
Copy is, service.
Yes, we have also exchanged that copy of Mr. Dev. You have also served upon Mr. Devray,
Okay.
It has not reached Mr. Devra.
because today itself we have given.
No,
So
yesterday. also-
today,
On prayer of
I'll
the,
serve with my clerk.
the matter is adjourned. Paragraph.
आज
The
की
matter appear under the same heading on
आगे की बताइए।
30th August, 30.
My lord, my lord, my lord, my lord. Deep low play.
ये थोड़े से तो दिखे रहा है।
Grateful.
Item number 108.
Supplementary affidavit file করে দিয়েছো? You know, here the grievances was that man at the permit though issued. But way back, permit issued way back in 2022. The timetable was not there. They haven't, proposed timetable was there, but they had not sanctioned or allowed to grant the timetable. Now, during the pendency of this writ petition, they issued the timetable. But the only thing is that the timetable issued for a short period. So my lord, I have filed a supplementary affidavit to the effect that
Today,
no, the last occasion I have filed my lord, the supplementary affidavit. And my lord, there I have stated that the timetable given for a period of first the 14 days, then for the 1 month, then it is going to be expired on 28th of August. On a instant this month, this will expire. My lord, I have annexed the timetable also therein. So there, oh my lord, this, oh sorry, my lord, this is the timetable, my lord, which has been handed. No, no, no.
Supplementary
Timetable to annex করেছেন? এই
আমার
timetable
copy দাও,
করেছেন?
আমার কাছে নেই।
That is there. Yes, yes, I have. Yes, my lord, I have annexed the timetable. Page 17.
yes. Yes.
Yes, my lord, now thereafter it has been extended. That your lordship will find that the next one that has not been annexed because the extension given on on 27th of July. So that it is earlier copy. So it has been extended up to 28th of August. So my lord, that is for 27th of from July to August 28th. So now for 1 month, well, it has to be extended for a period, at least for a period of 6 months or something else, because each and every time 1 month, first of 14 days that is there, then it is for 1 month, then it is for another 1 month. So now it will going to be expired at this instant this month on 28th. So when I let this, and I have filed the supplementary on that grounds. Permit 2027. That I have annexed, my lord. Your lordship can see. The permit annexed with the writ petition, my lord. Yes. And that is at page 16 of my writ petition. Page 16, your lordship will find that column number 8, date of expiry,
Yes.
2027.
It is here, Mr. Sen.
My lord.
My lord, initial grievance was there that no timetable was issued. Thereafter, my lord, whenever, my lord, the petitioner was, my lord, called upon there to attend for a hearing in the matter, and my lord, notice also served upon the other, some of the operators, because if the timetable is to be issued, because my lord knows is that the timetable, normally a proposed timetable is to be submitted with the motor vehicle authority, the permit issuing authority, and that proposed timetable is to be considered. Now that proposed timetable, while is to be considered, the others who are on the same route and or my lord, to some extent, same alignment, my lord, their, my lord, views are to be taken, because if the timetable is issued and it's a class of timetable with others, then again, my lord, that exercise is to be done. So that is why then every time, my lord, he raised objection, and this writ petition filed that why the others' views are to be taken, and actually the timetable is not issuing in my favor. Now, my lord, eventually during pendency of the matter, after my lord taking notes of others who are also on the fray and in the route they are flying, others' timetable after having been considered, then this timetable issued to him. Now, my lord knows that timetable always, there is no such permanent timetable. Timetable always for a certain period. Now here,
For 1 month.
let it be issued for 1 month or for, it has been issued for, and then it is, my lord, time to time, whenever he, my lord, submitted this, my lord, it is normally, my lord, extended for another 1 month or for another 2 months. But
We should for 3 months at least.
I leave it to your lordship. That I cannot want to stand in the way. I leave it to your lordship. That after all, a decision has been taken.
And that too, my lord, after
It
the
cannot be a-
opportunity of hearing all the objectors.
Yes,
or all
I am
the
not on that.
stakeholders.
These are facts.
Thereafter, it has been issued. So my
When
lord,
a-
there should
when a
not be any
decision-
objection to that.
When a decision has already been taken, and after taking consideration of all, so let it be for the time being 3 months. I have no objection. Let it be by a court order, my lord. Because always timetable, my lord, on the top of it, it is a provisional timetable, always.
The petitioner is a holder of permanent permit being numbered.
And Mala, only one thing, Mala, that the present writ petitioners has, for the time being, has no further grievance with regard to timetable.
Number 2026/2022 in the route Gopi Vallabhpur and Bakura. Stop. No timetable was issued in favor of the petitioner, for which the petitioner, comma, in the present application, comma, sought issuance of timetable in his favor. Stop. During pendency of the writ petition, timetable was issued in favor of the petitioner. Upon considering the opinions, the opinion of other interested operators, for a period of 14 days, which was subsequently extended for a period of 1 month and is due to expire on 28th.
On 28th.
On 28th August 2023. Stop. Paragraph, the petitioner, learned counsel for the petitioner submits that he has no grievance, that the petitioner has no grievance with regard to issuance, with regard to the permit issued in his favor, and prays for a direction upon the authority,
Well, timetable in this.
issuance of timetable in his favor, permit with regard to issuance of timetable in his favor, permit the timetable, and prays for a direction upon the authority to extend the said timetable for a period of at least 3 months at a stretch. Paragraph, upon consideration of the submission made on behalf of parties, comma, this court is inclined to hold that nothing further remains to be adjudicated in the writ petition, and the same is accordingly disposed of.
Except lordship not extended because time has not yet crossed. So let the direction be given upon the authority that time, that the validity of the timetable be extended or be kept till such and such period.
Paragraph, the concerned authority being the secretary,
Secretary.
being the fourth respondent here in comma, is directed to extend the validity of the timetable for a period of at least 3 months.
From the date of
The
issuance.
date of, from the date of
From the
expiry.
date of expiry. Yes.
No. From the date of expiry.
From the date of expiry thereof.
From the date of expiry.
Disposed of bolna mudha. There shall however be no no affidavits will be like.
My lord, I think instead of from the date of expiry,
From the date of expiry.
my lord, from this date, my lord, because from the date of expiry, my lord, there will be some confusion. So
From the date of it will be
From the date of expiry thereof, Janto, comma, that is.
that is the
28th of August.
20.
August 20. Last line,
Well,
last line. From the date of expiry thereof, comma, that is. Expiry thereof, comma, that is, comma, 28th August 2023.
Much okay.
Yes, 109.
Yes, madam. Right.
State, Mr. De. Respondent number 7,
Affidavit of service has been made and they appeared on 23rd June. Your lordship kindly have a look, the order dated 23rd June.
Yes.
After the matter was appeared, my lord, twice. They did not turn up.
The state wanted to submit a report.
No report has been submitted.
Who is appearing for the state? Mr. Dey is appearing. Where is he?
Mr. Chondi Charan De, my lord. Mr. Chondi Charan De.
Yes. They and Mr. Shortcut, they were appearing. Where are they? Private respondent is also not there. So now where are they?
Kindly make it not to them. So they will inform Mr. Day or make it pass over.
Not today.
Not to them.
Or let it be appeared on Monday. I am also informing them.
Not today.
No, one. My lord, one order may be passed, my lord, so that I can inform them.
Not today, no order.
Pursuant to lordship earlier direction dated 18th of July.
I am appearing, my lord. 110.
Hey,
Supplementary affidavit copy has been served.
just now. Yeah, what is the
Mr. Shamanto, an advance copy should.
the order of the court?
Whatever it
My lord, your lordship, can make it not today, my lord. Make it not today. And private respondent says he's not there, my. Private did not serve.
serve the private respondents.
Yes.
7 days, serve in the meantime.
My lord,
7 days.
7 days.
Serve in
Not
the
yes,
meantime. Supplementary affidavit submitted on behalf of the petitioner is taken on record. Paragraph copy of the affidavit is made over to learned counsel for the state respondents in court this day. Paragraph none appears for the private respondents. Paragraph let the matter appear under the same heading on 25th.
My lord, after 28th, my lord. After 28th.
29th. 29th?
Deep.
29th.
Number 111.
Yes.
Sir.
It's appearing.
Last occasion, my lord, there was a direction.
My lord, last
petition.
respondent was, the service was not clear on the last date. My lord, so the envelope has been returned with a endorsement refused. And my lord, I have served through email also.
Others?
Others has been served, my lord. My lord, here is the, others were served, only last were due, my lord. My learned friend is of the view that since he is the party, so.
All the districts.
My lord, all have been served. Sir.
Twenty-nine, 30.
All have been served, my lord. By email as well as a speed post, both means I have served. My lord, all were state respondents.
The postal receipts.
My lord, postal receipts were in earlier affidavit of service.
Earlier occasion, my lord have checked it and my lord.
Page
was
number
pleased
8
to
on.
Direct to serve a fresh.
Page number 8. This is your
Earlier affidavit. My lord, page number 8 onwards. All were state respondents. Only one,
private respondents.
only 2 were private respondents, my lord.
You said you served them.
My lord, through email as well as the speed post.
Where is the
One,
speed post service?
my lord, in the earlier affidavit of service, my lord, the postal receipts are annexed at page number 8 onwards, and tracking report was handed over separately, my lord. And right now, I have also handed over the afresh tracking report, my lord, and email receipt also. My lord, Transport Department has issued the private respondents the copy of the impugned order. So in those email ID, I have served, my lord.
Private respondent, one of them is not served as I can find.
My lord, and his
Not delivered.
yes, my lord, and my lord, the return envelope has been annexed in the last affidavit of service, my lord, with a endorsement refused. And my lord, email copy is at page number in the last affidavit of service. Email copy is after that, my lord, after the envelope.
And the other private respondent?
My lord, he has received. The other private respondent has received. Only one respondent is due who has not received. My lord is of the view that to bring the track report, my lord, on the last occasion, my lord.
Who is that respondent?
My lord, the envelope which was returned, my lord. Only that respondent, my lord. My.
Mr. Dhar, for all the state respondents?
Yes, all the state respondents. But I don't know whether respondent number 29 or 30.
One
Whether
served, the other refused, so it amounts to service.
My lord,
What is the matter?
my lord, may I take your lordship to page number 51 of my writ application, my lord?
Yes.
My lord, there was an order of your lordship, my lord. I am reading the portion, relevant portion. Upon considering the submission made on behalf of the parties, writ petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner dated 10 January 2023 within 6 months from date of communication of the order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner and private respondent, in accordance with law. It is made clear court has not gone into the merits of the case, and concerned authorities shall be at liberty to deal with the representation independently upon taking into consideration the submission made on behalf of all the stakeholders before it and documents submitted. My lord, thereafter, may I take your lordship, page number 58, my lord, the impugned order. 58.
Yes.
My lord, I am aggrieved by paragraph 6 and 8 of this order only. My lord, with regard to paragraph 6, the director has observed something which has been deprecated by the Secretary of Transport. The Secretary of Additional Secretary Transport, my lord. May I take your lordship to page number?
This is your submission.
This is my lord, this is not my submission. It is his observation, directors. My lord, page number 40, my lord. Both things are contrary. Whatever director has stated and whatever government has stated. The government has stated in page number 40, my lord, I am also directed to inform you that Honorable High Court passed an order dated 18/2/2022, granted liberty to registering authority to consider all the relevant material with regard to pending proceeding in TS 27 of 18 at the time of registration. But practically, it is not possible to assess the technicalities, as department does not have the technical expertise to differentiate between the EV technology used
in your vehicle vis-a-vis prohibited by the learned district judge, White injunction order dated 24/2/2020. My lord, the secretary is saying they are not having the expertise, and director is going above the secretary and making this kind of observation, which is, my lord, paragraph 6. It is revealed, page number 58, my lord.
Yes.
Impugned order. It is revealed that petitioner company is an automobile manufacturing company which manufactures electric three-wheelers, and petitioner submitted documents that battery of the electric three wheels manufactured by the Kinetic Green Energy is a lead cell battery which is different and distinct from that of battery which is subject matter of TS 27 of 18 of learned additional district judge. The petitioner also submitted e-vehicle manufactured by them comply with rule 126 of Central Motor Vehicle Rule 1989. My lord, this portion, and my lord, at page number 59, due perusal of the relevant paper produced by the petitioner and following solemn order passed by Honorable Justice SUVRA GHOSH, Calcutta High Court in regard to 67 cases similarly placed pertaining to the same subject matter dealing with the instant case, it appears that battery used by the petitioner is distinct. How can it be, my lord? How can he be a judge? Director can be a judge. My lord, secretary is saying they don't have the technical expertise, but director is treating himself as a judge and declaring all those things which are subject matter before the civil court. How he can observe like this? Being a party, he has become judge of his own case. He is the party before the civil court.
Lord, 40 in respect of page number 40, that's a communication. Kindly come to that 29th March 22.
Yes.
This is a communication between secretary and the zonal head of Mahindra and Mahindra.
With some recordings, with some observation.
Yes.
That they do not have the infrastructure.
During that time, the authority was not in a position. But after my lord's order, now, my lord, so much water has percolated, my lord. Now authority is in a position to ascertain that which one has got the patent and which does not require, or that is different than the patent. But only that bit was taken into consideration. What is the harm?
My lord, I am
particular communication does not bind.
My lord, I am disputing my learned friends of view, my lord. My lord, under Article 141 of the Constitution of India, which clearly says whatever High Court passes the order, it depends upon the subsisting law of the land. High Court cannot make the law. High Court is implementing the law. The law-making power is Article 142. If they want to make a separate law for declaring the director as a judge or for getting any order which is contrary to the Honorable Civil Court's order, they must have go to Supreme Court. Under Article 142, the Supreme Court is empowered to empower them.
So far as I can recall, all the orders said that it can be provided subject to determining that the battery is different and distinct from the other. The battery involved in the title suit.
My lord.
So who will do this?
My lord, this thing, my lord.
The authority has to do it.
My lord, this thing, my lord. With regard to this, my lord, may I take your lordship?
Come back with a report in the form of.
My lord, I'll come back with that.
My lord.
About your infrastructure.
Yes.
My lord, may I take your lordship to section 213 of the Motor Vehicle Act?
How you have come to the conclusion? that
Yes,
this is
I'll come back with that.
My lord, I am having question about the maintainability of this observation, my lord. May I take your lordship to section 213? My lord, in some of the orders, director was directed to consider all the representation with regard to 67 cases. And my lord, in some of the matter, my lord, registering authority were directed as per the request made by the Learned State Council, my lord. My lord, section 213 of the Motor Vehicle Act, since this is a motor vehicle department, so they have to abide by the Motor Vehicle Act and CMV rules. So the state government may, for the purpose of carrying into effect of the provision of the act, establish a motor vehicle department and appoint as officer thereof such person as it thinks fit. Every such officer shall be deemed to be public servant within the meaning of Indian Penal Code 45 of 1860. State government may make rules to regulate discharge by officers of the motor vehicle department of their function, and in particular without prejudice to the generality of the foregoing provision prescribed the uniform to be worn by them. authorities to which they shall be subordinate. The central government may having regard to the objects of the act by notification in the official gazette prescribe minimum qualification. In addition to the powers that may be conferred on any officer of the Motor Vehicle Act, such officer may be empowered by the state government in this behalf shall also have the power to make such examination inquiry as it deems fit in order to ascertain whether the provision of the act and rules made thereunder are being observed. My lord, this is the power. 213I, any such search without a warrant shall be made only by an officer of a rank of gazetted officer, where offense is punishable. My lord, whether section 213 empowers the registering authority or director to pass such kind of observation in which he is a party, civil court, he is a party, my lord.
I feel the court has empowered them.
Yes.
My lord, court has not empowered, my lord. If your lordship go through the order,
I'll
my
justify
lord,
how I have distinguished.
Yes.
My lord,
By which, by the.
my lord, your lordship's order were based on 3 terms.
It is over for the day, sir.
My-
Let them come back with the report. Affidavit of service. Paragraph, none appears for the private respondents despite service. Paragraph. The petitioner is aggrieved by the observation made by the
Yellow.
director, transport director, Government of West Bengal, in his order passed on 14 June 2023. Stop. Paragraph, learned counsel for the state respondents seeks to submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 8th September.
My lord, then observations are subject to result of the writ petition may be made out, my lord, or otherwise I will suffer irreparable loss. My lord, memos were implemented. I have no objection. But my lord,
Find that there is anything wrong in the observations.
my lord, it will be subject to the result of writ petition. Only that thing, my lord, because my lord, on 8, my lord, till date, my lord, there will be a violation because there is a civil court's order also. How can they can be a judge of its own case? My lord, they are the party before the civil court. Your lordship has been pleased to direct, my lord, subject to the result of the writ. My lord, that's what I'm praying, my lord. Kindly, my lord, subject to the result of the writ.
Next one.
My lord, this is that e-rickshaw matter.
112.
Can is not in the file, my lord. And my lord, on 17 July, my lord, in the identical matter, your lordship has been pleased to direct me to file report in the form of affidavit. In these matters, my lord,
Added as yet, sir. Please do
yes, my lord. In these areas,
can also.
my lord, I filed the can. In the list, can is not in the file, it's showing.
কি চাইছো গো? অঞ্জলি টেলার্স তুমি?
হ্যাঁ, সেম অর্ডার। কনসিডার করবে ওর থেকে আলাদা আমি সিভিল কোর্টে পাঠিয়ে নেব।
পার্টি বা পার্টি আলাদা, এটা তো অন্য।
না না।
My lord, item 111 to item.
আরে মামলাটা
My lord, I am the
117.
যে করছে পিটিশনার
I am
তাকে
the
করতে দাও।
petitioner. Submit.
Please, আপনি submission করুন না।
Your mouth before I am even.
এত স্মার্টনেস দেখি।
আমাকে সাবমিশন থ্রি
No, you are not required to submit.
আপনি করুন না, আমি তো কোর্টকে করবোই সাবমিশন।
My lord, application is not in the file.
My lord.
The application is not in the file.
অ্যাপ্লিকেশন নট ইন দ্য ফাইল।
Have you received copy of the application?
Yes. Yes. My lord, can I hand over my copy to your lordship?
I have one application.
Well, in the other matters, Mr. Razak is appearing for the.
So can the application be allowed?
My lord, so far as my lord can application which has been filed in item 13 to 17, my lord, we. 12 to 16. 12 to 16.
Let the applications be allowed?
Let the application be allowed, my lord. We have no objection to that, my lord. My lord, this matter has already been dealt with by your lordship at length. He had been added as. And my lord, he has been already added as a party in the earlier application.
Yes.
And we are, my lord, certainly not. If your lordship will just see page 146.
128 sir, 120 sir, आपका नहीं होगा 12 112 में
My lord, page 128.
Yes.
But here he had been added a party and thereafter your lordship had disposed of it.
Cellular move, na? Yes, my lord, in this.
At 128. Let this same order be passed? Yes.
Yes, same order be passed, my lord, because my learned friend, my lord, wants to be a party, my lord, let him be at his party. We are not standing in the way. And my lord, your lordship will find, my lord, orders have been passed. And
My lord,
my lord, whatever he wanted, that was added by your lordship will kindly see. Even the, my lord, at page 1, show me page 4. My lord, internal page 4 of the
friend is
document.
appearing in item number 113 to 17, if I'm
Yes,
not
yes,
wrong.
yes,
My
yes,
lord,
yes.
what, item number 112, my lord. he's
But you said now just now, all are being taken up together.
112.
My lord,
Appearing.
yes, my lord,
Yes.
page 130, second paragraph. My lord, my learned friend's consent is there. Second paragraph of page 130. Kindly see.
No, that is, honorable court is aware of my consent.
My lord, same
There's no
order be
dispute on
passed
that.
in all these.
Mr. Sinha, you must understand. People are not afraid of you.
No, my lord, I am not a, I am not a demon, my lord.
I don't
I am a
understand.
simple human
My
being.
lord, my learned friend professes to be, my lord, a scientist. He has come up with an invention. My lord, we are very proud of it. There's no problem. My lord. But that must affect our case at least.
Congratulations.
My lord, there must be some, my lord, infringement of his rights. If there is no infringement of his right, my lord, then in that way, my learned friend will have the magnanimity, my lord, to say, well, this doesn't. And that is why, my lord, he had given consent on the last occasion. Similar order, absolutely, my lord. And that covers it up. Even that earlier suit is to be considered. Your lordship
My
has
lord,
recorded that.
I am having no objection if the similar order is passed.
Yes.
But my lord, one fact is required to be brought on record before your lordship, because my lord, during the pendency of these writ petitions, I have filed a civil suit before Honorable Justice Arindam Mukherjee Lordship's court, and Honorable Civil Court has been pleased to direct mediation between me and the state authorities regarding this different category order. And mediation is going on 28th of August, my
How
lord.
are we
My lord, that will affect their case also. I have no, your lordship may take on record my consent, my lord. I am having no objection on the similar order, but that
That's
order,
a separate issue.
maybe, my lord, may kindly be perused, my lord.
It is no, because you don't have documents of mediation, nothing to do.
Mediation, nothing has happened. My lord.
That was as per the, my lord, there was some certain observation in that order. My lord, I
Let this order be passed. If there
My
is
lord.
mediation.
That
That-
issue,
my
that
lord,
issue is
something-
not before your
something-
lordship.
That
My
issue
lord,
is not
may-
here.
most humbly
Whatever the suit he has filed, it is up to him.
My lord,
Already suit filed, one in Calcutta High Court, other in Alipur Court, then again in High Court. It is up to him. Let him file.
My lord,
We are not parties to that.
What?
that is
Yes,
different.
very good.
My lord, my
Now
lord.
here,
In
my lord.
Other matter, my lord, your lordship has been pleased to direct me on 17 July to file a report in the form of affidavit, bringing on record that order, my lord. My lord, those matter we are also directed to be listed on 2nd of August. But since your lordship is not seen in the principal bench matter, we are not listed, my lord. My lord, let all this matter be brought on tomorrow. my lord.
There is no stay, there is no stay, nothing.
Disposed of because you are aware that a court order.
My lord,
is
just now he said consent is given, my lord, and now he's saying, yes, my lord, this does not happen.
I will bring that order copy.
No,
to
no,
your
no.
lordship. Just, my lord,
No,
I
my lord,
just want to
what?
place this
My
on for you.
lord, same order we passed in this case, and then, my lord, if he has anything, we'll see later on, my lord, mediation or whatever it may be.
Now take its own.
Yes, certainly.
My lord, then without,
Certainly.
my lord, may kindly then reflect without prejudice to the matter pending in other jurisdictions, my lord.
What are the jurisdictions?
No, no, my lord,
My lord,
those are
because, my
different.
lord,
Those
I
are,
will be able to
no,
produce
then
that
we are
order.
not parties, we are not aware.
There is no necessity
Connection.
for my lord,
Because, my lord, I am
for
not been able-
addition of his party here.
I am not been able to produce that order. That's why, my lord,
Take 6 months more to produce it.
no, I am taking half an hour if you, if
ওটার সঙ্গে এটার কি আছে? কিছু নেই।
Respondent number 4 is.
আসছে তো, তো problem টা
Address
কোথায়?
respondent number 4.
আসছে না? আসছে তো, সে তো শেষ নেই।
আগে কেন? Same order.
এর জুনিয়র
একটা তো আনতে হবে কোর্টের নথি।
মোটামুটি 50 থেকে 100 কোটি হয়ে গেছে। হ্যাঁ, ওইটুকু হয়ে
120 এটা কেন?
আপনি আমার থেকে অনেক বেশি ফেমাস।
নেই,
এখন তো ইউটিউব খুললেই আপনার চেহারা দেখে।
সে তো চেহারা দেখা। আপনি কি হবে? চেহারা দেখা।
I'll just call one by one because
Yes,
you
ma'am.
see
Yes,
the
ma'am.
number of the respondents.
Yes,
here.
ma'am.
Because here it is respondent number 4.
Yes. In the next one, my lord, in item 13, it's respondent number 6.
Well, I am appearing, well, 113.
112 is disposed of, lordship. 112 is disposed.
113, I am appearing, well.
My lord, in the
112 is here, these.
13, my lord, it will be respondent number 6, my lord.
I am appearing for this.
Yes, certainly. Certainly. Give me the other one.
112 ke dilo.
13 may be 6. Yes, 13 may 6. Then give me the other one. All
কোথায়
this is
চলো?
the
তো
same.
এখানে দাঁড়িয়ে আছে। 112 এর স্লিপ দিয়েছো? নাম দিয়েছো? তোমায় কে বলবে? তুমি মামলায় আছো।
হ্যাঁ,
কি করছে এরা বলো জানে।
By consent of
नहीं नहीं ये नहीं है वेर इज दिस रिस्ट्रिक्शन सब कहाँ है
अरे यार ये 12 कौन सा था 12 13 कौन सा है
13 yes MIM
13 में ही रिस्पोंडेंट नंबर
6 yes
14 में he
Item number 14.
Well, I am appearing, well.
Sir, also it will be respondent number 6 my lord.
I am appearing.
All respondent number 6
ये तो सर मेरे हाथ में है सर मेरे हाथ में है मंडल
না না 14 এ আমি নেই।
मंडल में
I am appearing, well.
14 এ বোধহয় বিয়ে আছে।
विश्वास
15 আমি আছি।
দিয়ে দে।
14,
stated item number 6
14 is
respondent number 6
I am appearing, well. 14.
उसके बाद वाला भी 6 है
14 हाँ
सर उसके बाद वाला तो सब में 6 है
obviously
Number 115.
I am
my
for
lord
the state,
here
my
also
lord.
it will be respondent number 6
6.
yes
I am for the
right
state,
up
my
to
lord.
17 it will be respondent number 6
দিয়ে দিয়েছি 15 আমি দিয়ে দিয়েছি।
हाँ देख लिया पूरा 16 तक है
Item number 16, 116.
here also my lord respondent number 6
मासूम में भी रिस्पोंडेंट
And
नंबर
117.
my lord
Well, I am
it's
appearing, well.
same my lord respondent number
I am
6
appearing.
deeply obliged grateful
Yes, next.
118.
grateful your lordship
I am appearing, well.
Yes.
Ashwarya Rajeshri, State Transport Authority. She is on legs. Kindly give short pass over.
Respondent number 3. Pursuant to your lordship, pleasure, my lord, I have served notice.
She's appearing, but she is in some other
I
court.
have served notice, but your lordship kindly hear me. Not formally, but-
In absence of the respondents.
but yes, my lord, respondent is there, my lord. I am seeking order, my lord, against the respondent number 2.
Who is appearing for the other respondents? Devra?
Yes, well. I am appearing.
I am seeking order, my lord, from the respondent number 2.
But you have implemented Jharkhand authority.
Yes, my lord, because my lord, Jharkhand has placed me in a travel.
Come back next week.
But you know, I cannot. But I am a cancer patient, my lord. I live in Giridih.
Not today. Monday, not today.
Next.
Not today only. Come back on Monday.
My lord, my lord,
I
my
will
lord.
not Sunday, so come back on Monday.
Lordship, kindly consider, my lord, this is a very crucial point, my lord. Very point. You look at player, my lord. And I have, my vehicle has been,
Please understand. I've just made it not today. I've not given you a long date.
my lord, I have served, my lord, your lordship, kindly. I have served the supplementary advance copy of the supplementary affidavit. I have served.
She's appearing, come back on.
Well, I have served the supplementary affidavit, let it be kept. My lord.
So give it on Monday. Give it on Monday.
I have served, my lord.
So I'm making it not today, so give it on Monday. Yes, next.
Item number 119.
Well, I am appearing, well.
May I please?
I am appearing for this.
Well, I am appearing on behalf of the petitioner in the last occasion matter of the heart. And I have served the copy and affidavit service was filed in the last.
He's appearing for the respondents.
Mr. Mukherjee appearing on behalf of the respondent. So I am
Private
placing the matter.
state.
Sir, I am appearing, well.
And Mr. Devrai also on.
Yes, yes.
Now can you see the page number 16,
Page number?
page number 16, annexure P1.
Yes.
Now I am holding a permanent stage carriage permit on interstate road on a serial number 7.
Yes.
My route is, my lord, Minnapur to Tata. This permit was countersigned by the state of Jharkhand and so timetable also valid, page number 20. And counter signature of the State Transport Authority Jharkhand, page number 19, which was valid till 2nd August 2025. And page number 20, this timetable, which was valid also till the validity of permit. Now, my lord, my grievance, because I am plying the vehicle in terms of the condition of the term and condition of the permit on the alignment route which has been assigned in the permit. Now, my grievance against the private respondent, that kindly see the page number 22. His permit, my lord, page number 22, my lord has got it. Serial number 7, Bishnupur to Tata via Mendipur, Kharagpur, Beharagoda. That permit also valid till 5th December 2023, serial number 8. And timetable, my lord, page number 25. This timetable was issued at the bottom, 24th December 2019, extended up to 5th December 2000 till the validity of permit, till the value of permit. And timetable on Bishnupur, Mendipur, Kharagpur, Beharagoda, and Tata. These are timetable. Now, my lord, next page, page number 26. Another timetable, petitioner has plying the vehicle at present on the basis of this timetable. At the bottom, my lord, this timetable was issued on 23rd October 2019. Before that, one later stage, kindly come back on page number 25. This timetable was issued 24th December. This is the last timetable. That is the final. This is the original timetable. And this timetable was issued 23rd October 2019, provisionally allowed for 5th till 5th December 2022. But this timetable has already modified earlier. On the this timetable, this alignment is another alignment, because the earlier timetable, Bishnupur, Mendipur, Kharagpur, Beharagoda. This timetable, the Tata, Ghatshila, Berhampur, Gopiballapur, Kharagpur, Keshari, Kharagpur railway station, Mednapur, Bishnupur, these are down trip, and up to Bishnupur, Mednapur, Kharagpur, Keshari, Kharkika, Gopiballapur, Beharagoda, Ghatshila, Tata. Malot, from Keshari to Beharagoda, Gopiballapur, this is my alignment of this road, because I am plying this one. This is my alignment. Malot, this vehicle is plying illegally on the basis of this timetable. Whether this timetable is genuine or not, can direct the authority to examine this, because timetable already issued, page number 25. On 24th December 2019, this timetable is valid till 5th December 2023. For this reason, I very much agree, because this is not the alignment.
Yes, yes, Mr. Debra.
Lordship, kindly direct the Secretary STA to resolve the issue, because the timetable issue, my lord, and also objected to ply illegally, that has to be looked into by the Secretary STA. He has the power. Secretary STA, West Bengal.
After hearing
because both the permit was issued by the Secretary STA West Bengal. That is why, my lord, that is after hearing both the parties, and they have submitted all the documents before the authority.
Yes, Mr. Mukherjee.
My lord, I need to file an affidavit, because, my lord, this is a case when, my lord, the issue related to what is the timetable is that. Now, my lord, issue relates what the relation is there. He has suppressed a specific material facts where, my lord, the State Transport Authority, West Bengal, as well as this, my lord, the petitioner and myself related to that. And the suppression is to that effect that he is operating a vehicle, and that was decided by the STA in a board meeting, that he is operating a vehicle, that vehicle in a different alignment which covers his actual alignment length of the route is.
That is
No,
the.
my lord, now, why?
That
The hearing was taken and the decision adopted. He has suppressed in this petition that hearing was
wrong,
taken.
but he will get the chance to appear before the authority to
Yes, the hearing taken, decision adopted.
After
My lord, I
examining
have
all
to
the
file,
documents.
because your lordship kindly appreciate one thing. If a writ petition filed suppressing all these facts that was taken into consideration by the STA and decided against him,
that he is operating that vehicle and on that route on a length which is covered only 150 kilometers, and he is operating presently on a route which is covered 200 something more than kilometer. He has to, well, your lordship kindly appreciate, on that basis he has to place a proposed timetable. This was the decision in that matter.
This writ petition has nothing to do with his timetable or his
Yes.
flying in a route. The
He
writ
is
petition-
what he is alleging. He is alleging against me.
No, he's two timetable. How he's flying the vehicle on the basis of the timetable which has been lost.
No.
Simultaneously. Yes,
He is alleging against me.
he is alleging that you have.
So lordship
obtained
kindly see that thereafter,
Examine.
this has been already examined, this timetable.
Your timetable has.
Yes, that is the decision, your lordship kindly see.
Where is your timetable examined?
Your lordship,
And the.
No.
And the state.
afterward, this was my timetable was examined, that timetable, which he raised that this timetable is a forged one or something else. That was decided.
Please show me the decision.
That's why I'm placing this decision has been adopted in 18th of December 2020. He was there, he was appeared.
No, I'm not there. What is wrong here?
Your lordship kindly see.
I'm not about this. What about documents? Must have happened to me. My client have filed them. Then the memo cost timetable. Okay, copy the देखिए. Okay, take copy.
না দেখুন আচ্ছা দিচ্ছি
Just সই করুন।
আপনার অবজেকশনটা কোন পেজে আছে?
অবজেকশন দিন। তো ডিএমকে দিয়েছিলাম যে এগুলো ধরে চলছে তুমি ধরো।
More so, my lord,
Except
not
the-
even the objection given.
The alleged forgery part has not been dealt with at all.
My
in
lord,
this.
the objection is not there, your lordship kindly see, in writ petition. To whom he has been referred this objection, because these are the routes.
Then
Even, my lord,
raised
the
the two
permit has
time
been
days,
given.
the
your
authority is
lordship kindly
facing
see.
this time all you.
Just, my lord, just I have looked into, my lord, there is no objection. Filed before the authority.
Authority
Your
will
lordship kindly
examine
see.
well after hearing both parties.
How? He hasn't
On the basis of
objected.
the
Where he has,
petition.
your lordship
I
kindly
will
see,
serve
there
the
is no
copy, I
objection.
will serve the writ petition.
Because his contention before the authority that you are.
No,
applying
that
for
is
the-
not.
The writ
Where?
petition.
Your lordship kindly see,
I
where
shall
is
communicate the order along with the writ
Says-
petition.
that your lordship can see in
Order
the writ
says-
petition, there is no objection in the writ petition, which he has urged for, that there is no objection at all. Your lordship can see where he has made the objection, where he has alleged, how the STA entertain. There is no objection at all. Your lordship kindly ask him, where is the objection?
Objection, my lord, page number 27.
Yes,
the
where?
Client informed the district magistrate because the
Who?
vehicle is
Then
flying
how
within
the
10
ST will
kilometers.
take up this issue? How the ST will
Now,
take up
my
this
lord,
issue? There is no objection.
my
So
lord,
far as
my lord,
the ST is concerned, he is the permit holder.
My lord's order will be communicated along with the writ petition.
How?
That will be
How?
treated as the objection. Then-
How the cause of action arose, my lord? How the cause of action arose? Where he has made the objection? The permit issuing authority, the STA.
Enclose everything. Authority
RT
will
is
examine
enclosing,
the-
my lord, I don't know how.
Take the decision after hearing both parties.
Who, both parties? You haven't served any objection therein. How the cause of action arose, my lord, I don't know how he has taken.
Paragraph 7 of the writ petition, you have referred to a representation before the authority. Which is this? Where is this representation? Paragraph 7 of the writ petition.
Paragraph 7.
Paragraph 6, I think, in my copy, paragraph
Yeah,
6.
respondent means the district magistrate also has been party and also the RTA because
Where is the representation?
page number 27. Because vehicle is flying within the territorial jurisdiction of the Malord RTA
My lord,
Jhargam. District magistrate is the chairman of the RTA board.
Who has issued the permit? Who will take the issues, take up?
Question
matter?
two,
The STF will take up the issue. How? No objection is there.
ST will examine the
Only
timetable.
STF. Neither the
So
secretary
what is
STF nor the
guiding?
chairman of the
We want
STF.
back the matter
Can-
to the
I don't know, my lord, how
ST
can,
after
how,
hearing,
how,
both parties will like that. You will-
How prejudice is-
because my lord, how, my lord, the writ petition filed against a challenging our decisions or the challenge this has been done by myself.
Absolutely wrong submission.
Who
Well,
has-
authority examine
who
the
has-
timetable.
who has-
Which timetable is the correct?
To whom he has to make the objection.
Has made an objection.
Here
before the
yesterday to
authority
discharge my lord
has
to
not Considered
Before the
Power of the
authority, who issued the permit, my lord?
before the district magistrate. you have made
Yes,
a
who issued the permit is issued by the state government. Mr. Debra is also taking this issue. Who, how the writ petition be treated? my lord, I
ST
don't
will
know.
examine the which timetable is the correct.
Will you
Who
file
will
a
examine?
comprehensive
The
representation
issue has to be made before who will examine, my lord?
I
Yeah, my lord.
have submitted, I made the representation
This
before
is
the
not-
district magistrate, for
please,
this vehicle is flying.
not
I
considered?
am trying to solve the issue, my lord. I am trying to solve the issue. Trying to solve the issue by
Let the petitioner submit a comprehensive representation before the secretary.
my lord.
Okay,
That is better, my lord.
Upon hearing both the private respondent and the.
Yes, I agree.
Because ST is the authority, permit issuing authority, both the petitioners and respondent.
Is that all right?
Can your lordship kindly see?
Deeply obliged, my lord.
Your lordship kindly see this type of writ petition, my senior friend, my lord, he has filed this writ petition.
A litigant come, a client relationship with the advocate and underlined by utmost trust. So my lord,
No objection,
refuse.
no cause of
So now-
action.
the objection can be.
Third level counsels for the parties.
এইটা তোমার আমি নিয়ে নিবো।
This contracted on behalf of that the petitioner is a stage carriage permit holder. The interstate route, Midnapur to Tata. And his permit is valid till 2nd August 2025. Stop. Timetable issued in favor of the petitioner in the said route. For the said route is also valid till expiry of the permit. The petitioner alleges that the private respondent
Within 6 weeks, my lord? I am not audible, my lord, lordship kindly see. Within 6 weeks, my lord. Deep loop, please.
They obtain the permit another road, they are flying the vehicle on our road. So, my lord, we made the representation.
To whom?
Now, my lord,
কার কাছে রিপ্রেজেন্টেশনটা দিয়েছো?
Normally, so far the e-rickshaw is concerned, ultimately, my lord, our state scale service are seriously, my lord, hampered.
রিপ্রেজেন্টেশনটা কার কাছে
Flying
দিল?
of the vehicle. So, my lord, in case of my lord e-rickshaw, I made the representation. আমি একটু বলে দিচ্ছি
আমি কিছু বলছি না, বলো।
My lord, kindly see the page number 76. In case of e-rickshaw, my lord, state government transport department, government of West Bengal, issued a notification on 27th April 2015
এত বাজে
regarding the registration of the e-rickshaw as contract carriage without my lord, my lord, 6-7 paragraph, 6th paragraph.
Yes.
And while the e-rickshaw are to be registered as contract carriage is defined under section 2(3) as motor vehicles, and all the procedure for registration, certificate of fitness, permit, e-rickshaw is there. Now the guideline also issued, next page, page number 78, page number 78.
Yes.
Guidelines, my lord, also 6th paragraph and middle portion. The overriding principle here that e-rickshaw will be allowed only for last mile connectivity, not on major state, national highway, etc., where no last mile connectivity, only lanes and by lanes where no other transport service are available. And so page number 79, my lord, the legal frameworks in middle position, and
Last mile connectivity.
serial number 3 will be allowed only when to provide last mile connectivity public interlitigation, the very large number of e-rickshaw supplying the vehicle. So this writ petition also disposed of. My learned friend appear, my senior friend appear on behalf of the state respondents, and my lord,
This writ petition is also a public interest.
19, page number 90.
This writ petition is also a public
No,
interest.
because I cannot file public interlitigation because
In
I'm
fact,
the operator.
Mala,
But I'm the operator. Operator cannot.
in fact, Mala,
No, I'm bullshit.
I just, my lord, want to
No, no,
say that my lord, the
This writ petition was issued public
the
interlitigation.
tenets and my lord, the object, everything is my lord regarding public interest litigation. And my lord, the
File one
bus
letter,
operators,
the writ was dismissed on the
my
ground.
learned friend himself on behalf of bus operators moved that bill, public interest litigation. Now he says that
No,
order
these
is
are
passed.
public.
There is an order, already order, contempt proceeding is pending.
To make my submission.
Who is the filed the writ petition?
Order. Is
Yes,
PIL order.
yes, page number 90. Because why? If this unregistered vehicle took place the accident, will suffer public, he will not get the benefit. On this ground, the writ petition was filed, nothing else. Well, here in this case, my lord,
No.
a restriction was, my lord, here passed the order, no e-rickshaw will be allowed to ply on the road without restriction. And kindly see the page number 90, and my lord, relevant portion, page number 91, last paragraph, page number 91, last paragraph, having hard learned counsel for the parties, we direct the responsibility to ensure that all registers are plying in West Bengal are registered with the regional transport authorities subject to compliance of such vehicles under Rule 126 of the Central Motor Rules. And also cut-off date, page number 92. Cut-off date, page number 92. Middle portion, my lord, sorry, the second paragraph, we trust that
Made the Same prayer in the present.
Same
report.
prayer, same prayer.
Cut off 3 months.
And my lord also filed contempt proceeding against this.
So the e-rickshaw is concerned, so what the other rickshaws are coming. And so the, this,
Rickshaws are concerned, your retreat is not maintainable.
no, unregistered vehicle will not be allowed to ply on the road. Or because they are carrying the passengers on my road. But why are prejudiced? These e-rickshaw plying on my road, only on this ground, I am prejudiced.
There are several contempt petitions pending. We have filed, my lord, our respective affidavit.
Auto rickshaw is concerned. So far the auto rickshaw is concerned.
সব একসাথে করেছো কেন?
So far the auto rickshaw is concerned. Now kindly say the page number 99.
Page number?
Page number 99. Page number 99. Page number 99. 29 January 2010, this policy was issued, and page number 100, so many guidelines that no new auto rickshaw permit will be issued 30% bus route, and not to be allowed to ply state highways. Now my vehicle was flying on state highways, violation of flying, so I am prejudiced. So I made the representation before the district magistrate and secretary, let them direct to take decision on in the decision on representation, so nothing else.
It cannot be. It cannot be. What is, well, let him finish first. Let him finish first that what the representation.
The e-rickshaw part has been dealt with by the.
Yes.
So that part cannot be considered in the present petition.
And now my lord, so far,
But unregistered.
তুমি যদি না শেষ করতে পারো আমি কি করবো?
Sir,
without registration.
That is the.
My service is prejudice because my passenger is here.
dealt with in the public interest.
Yes,
litigation.
and my lord,
I'm the
the
operator, I cannot move. I'm the operator, cannot move. I move, initially I move because go to writ petition under group settlement because you are the operator, you cannot.
Petition is in the public interest litigation.
No, this petition was made by public.
No.
Before the division bench.
No, they were also the operators.
No operator was moved.
Show me the writ petition, the.
Yes, I tomorrow I'll fix the next day.
Let
Next
me
day,
come back with the
and so far the other
Because once it has been, the same issue has been decided by the PIL bench.
Whether, my lord, their status, whatever be their status with regard to the, my lord, the writ petitioners, ultimately the issue was the same. And my lord, the practically speaking, my lord, may I tell, 3 or 4 contempt applications are pending before the division bench. My lord, is also.
Auto rickshaw, not a without.
And my lord,
without my flying.
he is not allowing me what I can do. I think he has already agitated his grievance. No, very good. This is the prayer, but তোমাকে থামতে তো হবে একটা সময়। কি মুশকিল? Now, why tomorrow? This is his prayer. Now, my lord, kindly, unless my lord, his prayer is allowed, my lord, he would not allow anybody. This is not like, now lordship, kindly come to page 104. This is his representation to the district magistrate and chairman RTO Puro Mendipur. Now, my lord,
representation page number 120.
প্লিজ এই ধরনের এতদিন প্র্যাকটিস করার পর এইটাকে তোমার এনো না, এত বছর প্র্যাকটিস করেছো না my lord, this representation, let us my lord assume that with regard to the my lord, the auto or toto, my lord, he is not my lord making any submission or not prayer. But my lord, kindly have a look. how this representation can be dealt with by anybody, be especially the authority. বেশ কয়েক মাস ধরে রুটে 20টি ট্রেকার টাটা ম্যাজিক, 10টা যে সকল ট্রেকার গুলি গ্রাম্য এলাকা, I am not going to read any further. No particulars, no, my lord, the particular route or area, no particulars. How can, this is a very difficulty. Please stop. Now, my lord, no particulars, no vehicle number, nothing. Now, my lord, authority, it is not possible because this type of representation, this is nothing new. But the other, my lord, those who are in the fray, those who are the other operators, they time to time, they have come and filed this representation and then come to court. But the direction of the court always there, that unless the specific vehicle number is there or specific, Mala, it is not possible that the motor vehicle inspector or the police authority, they can, Mala, stop all the vehicles on the road. And they would ask them, what is your paper? Where is your paper? This is not possible. On a route, so it is his Mala, duty or responsibility to place that there, these are the number, at least 10, 15, 20. But these,
without registration, how is it come?
Given by the PIL bench. That
Yes.
is to ensure that all the auto rickshaws are registered.
yes.
All
So was the taker in
e-rickshaws
concern
are
also the
Yes.
same without permit?
Now,
without
may I,
registration?
now,
Page number 12, 20.
আরে তুমি যদি বলতে
Comprehensive way, page number 12.
very difficult. জজ কি বলছে সেটাই বুঝতে পারছো না। মানে this order was passed that within a specific date,
Yes, yes.
the auto rickshaws, I mean e-rickshaws, should be registered. It was the order. After that, my lord, more than 50,000 or 80,000 auto rickshaws have been registered. But in the meantime, my lord, the order passed by the in Mr. Konik Sinha's matter, that there, my lord, all the, my lord, the registering authorities are restrained from my lord making this registration. Then my lord, everything stalled. Then one after another order is passed by your lordship and another coordinate bench that if the e-rickshaws, their manufacturing or their battery is different, then can be considered. Then again, my lord, registration is now, my lord, I think it is now started. Now, because almost 2 or 3 years, everything was stopped because of that interim order passed by the Alipur court. Now, so far that, my lord, the appeal matter is, public interest litigation matter is pending, order passed, contempt proceeding is pending. We are facing the contempt. We have already filed 3 or 4 time to time report before the court. Now it is before the court number 6, my lord knows that. Now, so far this representation is concerned, unless anything, any particulars are concerned, my lord, this representation cannot be, my lord, considered.
My representation 120, 177, because comprehensive representation.
He said that
Against
there are
taker
numerous.
without permit,
There is a 330 resolution.
taker,
Yes,
taker, auto rickshaw, magic, then not only e-rickshaw only.
Third learned counsels for the matters. Paragraph, let the matter appear under the same heading for further consideration on 29th August.
29th August, my lord.
But I have also, NS also photograph also, without.
Mr. Khan, please think over. I
No,
have
no,
a
no,
doubt
no.
with regard to maintenance of the.
Yes. বলতে দাও না।